use a voting. Your Lordship's kind.
Matter may be taken up at 2:30 p.m. along with other matters.
Reservation. Reservation matters 2:30. Yes, madam. Tomorrow.
I filed an IA for restoration, my lord. That was dismissed.
Tomorrow. Yes. Yes. Tomorrow. Yes, tomorrow. Tomorrow, madam. Right, today or tomorrow? At 2:30.
Lord's kindly.
Yes.
Lord,
Yes.
one matter pertaining to the Arrowed bench.
Yes.
Lord, sir. One application for correction of the order is filed. The urgency is that Assistant Commissioner has now declined to enter the names because there is mistake in the cost set. Lord, sir. I'm just requesting your Lordship to list order to list it.
10th October?
Please, will.
10th
Please,
October.
Please. WP number 66255 of 2020.
Will listed on
2010.
WP number.
Please. 66255 of 2010.
Submission, my lord. My lord, serial number 34, my lord.
Madam, wait. When the matter is called, make a mention. What is 822 matter? Interim order is operating. But anyway, interim order is operating. Either but 22 matter, let it come up. Allah, without him filing objection, I cannot dispose it of. Interim order is operating. 2047 at request learned counsel for respond number 1 into list on 11th October.
Serial number 72, my lords.
Villa, wait, move on. 1 minute.
Matter is called out balloon cannot make any consider because
See, when he is not ready to get to file objection, but file objection, ready to matter. Yes, interim order granted earlier.
Number 8, serial number 58.
Yes. Electrical learn constitutional list after vacation. Inform other side.
I appeal for the respondent number 4.
Inform other side.
Yes.
State at request of learned counsel for respond number 4. List after vacation. Yes. 72 at request of learned counsel for respond number 4. List after vacation. Inform other side. When do you want? After 83 at request of learned counsel. Respond number 3 and 4 list after vacation. Interim order granted earlier. 30th.
82.
Interim order India. Extended till the
82.
yes.
I need to tell the applicant.
82 at request of learned counsel for respond number 4.
4.
After vacation. Inform other side.
Number 92. Page number 14, serial number 93 and 94.
Yes, yes. Yes. Yes, what do you want tomorrow? At 2:30. Wait, mention on the matter report. Yes, 9, serial number 9, 2:30, 10. Serial number 10, 2:30.
Serial number 1.
Yes, yes. Madam, autograph.
Pointed out. Those are the 2 minutes.
Page number?
Second petition is represented by PPA holder, then details are not come. And then whether in paragraph 2 minutes. Paragraph 2.
Yes, sir.
On 13/3/95, the petitioner is the petitioner Suresh Miscellaneous. My vendor's vendor, because I became the purchase the property only. The paragraph 2 I extracted as it is.
You should delete petitioner and
Suresh
Suresh Bhosle.
And then you had Municipal Corporation Act in 76, not 75. And then in the last sentence has been added.
76 correct ಆಗಿದೆ. ಇಲ್ಲ 76.
And last sentence is to be added.
In the meantime. Madam, ಇದಾದ್ಮೇಲೆ ಇದಾಡ್ ಮಾಡೋದು. Page number 3, para 2. Order curated, conveyed finish, order dated 13 September 20. Yes. Yes, yes.
Serial number 2.
All of them shall be complied. Election A, we find the computer is compliant. On 11th August and 16th September,
Yes, yes.
of state election, the operation of election A. So this matter, I was actually trying to 65 separately. In 65 is an executive order, saying election A, my lord, collection of full property tax under further orders of Honorable Court as per W number 12954 of 2020.
Yes. List this matter along with WP number
12954
12954
of
2021. Learned AGA for respond number 1. Banu Prakash, you have filed respond number 1. Operation of the circular dated 29/3/2020-2021 issued by respond number 2 at annexure A is stayed. Office objection overruled. And for granting.
That the assistant commissioner passed an order for eviction. That is not challenged. So for non-implementation, I gave representation that was not considered. Therefore, I filed a writ petition. In the writ petition, they issue an endorsement saying that this property is acquired. Whereas I have produced the document, this property is not acquired. So I am challenging an endorsement. It is by the grantee manner.
Produce document.
Please. I am permitted to take notice.
Done with the CGP for respond 1 and 2. This at request of learned counsel petition list after Civic.
No other is having filed in currently elected. We have already listed that. And there is one more.
Srinidhi, what is to be stated in the Pranishya C. Yadav and a copy kotillo. Madam, furnish a copy. That's why I didn't know which all under what heads.
Yesterday a lot.
654. Learned counsel for the petitioner submits that the coordinating bench of this court in learned counsel for the petitioner submits that in identical matter, the coordinating bench of this court in WP number 654 of 2021 has granted 2022 has granted interim order to stop this matter along with WP number 654 of 2022 operation of the impugned demand notice dated 6th August 2022. In conditions is the other. Yes, yes. %, madam.
Yes.
Subject to the condition, the petitioner deposits 50% of the demands made at serial number 2 to 7 to 15.
Yes.
7 to 15.
Yes.
50% of the demand made at serial number 1 and 2.
Yes.
1 and 2 and 7 to 15.
Yes.
And in so far a demand made at serial number 3 to 6, the same is subject to the outcome of this writ petition. The said amount, full stop. The amount to be deposited within 4 weeks from today, and also the petitioner is required to file an indemnity bond for securing the payment of balance amount in the event of failure in the writ petition. Any other upon deposit sanction plan? Yes, yes. Upon deposit of the said amount, the respond number 2 to grant sanction building plan and also summons certificate and commencement certificate. Grant is okay. To grant sanction plan and also commencement certificate in accordance with law. Forthwith. Yes, madam. Yes. Yes. What is thought, madam? Learned AG for respond number 1. Who appeared for CH-20? Yes, madam. Sharon Majige, learned counsel, access notice for respond number 2. List after vacation. List on 11th. Learned ಯಾರ ಪೇರಾಗಿದ್ದಾರೆ ಅದರ ಸೈಡ್ BBMP learned AG for respond number 1. Hello, who appeared for BBMP in other matters? Chan Chandra, learned counsel, access notice for respond 2 and 3. Lakshmi Rao, learned counsel, access notice for respond number 4. This along with WP number 41. Yes, ma'am.
My lords, I am appearing for the petition, my lords, serial number 7, my lords. My lords, the petition is challenging the annexure D, my lords. That is page number 52, my lords. The third respondent has filed an appeal invoking after lapse of several years, my lords.
How many years, madam?
My
When
lords,
was the sale made?
yes, my lords. This honorable court has been pleased to grant an
7. 7, yes. 7. Six, yes.
My lords, annexure G is the interim order passed by this honorable court in the same matter, my lords. Another petition, another appellant respondent, my lords. Annexure G is page number 70, my lords.
17 years. Is this?
Please, my lords.
This is second sale.
My lords, I am not audible, my lords.
Yes, madam. You are audible, madam. Learned,
Annexure G is the interim order passed by this honorable court, my lords.
CGP correspond 1 and 2. Issue of major notice respond number 3. List this matter along with WP number 19395 of 2022. Any
My
other
lords,
ground? 1 minute.
15670, my lords. Connected other matter.
One minute.
I have produced a copy at annexure G, my lords.
Yes. ನೋಡಿ ಫಾರ್ಮ್ ನಂಬರ್ 1 ಅದು 1 ಆಕ್ಷನ್ ನೋಡಿ ಸಿಗ್ನಲ್ ಕೊಡಿ ರೂಪಾಯಿಗಳ they mention the amount ಇದೇನ್ ಫ್ರೀ ಕಾಸ್ಟ್ ಇದು ಫ್ರೀ ಆಫ್ ಕಾಸ್ಟ್ ಅದ್ ನೋಡಿ ಅದನ್ನ ಅದು ಅಮೌಂಟ್ ಇದೆ ಅದು ಕೊಟ್ಟಿದ್ದಾರೆ ನಾವು ಟೈಪ್ ಕಾಪಿ ನೋಡ್ಬಿಡಿ ಮೇಡಮ್ ಫೈಲ್ ಪ್ರಾಪರ್
I have my typed copy is annexure
ಟೈಪ್
C.
ಕಾಪಿ ಮಿಸ್ಸಿಂಗ್ ಮೇಡಮ್ ಸ್ಟ್ಯಾಂಡರ್ಡ್ ನೋಡಿ ಸ್ಟ್ಯಾಂಡರ್ಡ್ ಫಾರ್ಮ್ಯಾಟ್ ವೆದರ್ ಅಮೌಂಟ್ ಇಸ್ ಡೆಪಾಸಿಟೆಡ್ ಆರ್ ನಾಟ್ ಮಾಡಿದಾರಲ್ಲ ಇದೆ ಮೇಡಮ್ ಇಟ್ ಇಸ್ ಎಂಬುವರು ಇದು ಆ ತರ ಇಲ್ಲಲ್ಲ ಫ್ರೀ ಆಫ್ ಕಾಸ್ಟ್ ಅಂತ ಅದು ಏನಂತ ಬರ್ದಿದ್ದಾರೆ ಫ್ರೀ ಆಫ್ ಕಾಸ್ಟ್ ಫ್ರೀ ಆಫ್ ಕಾಸ್ಟ್ land granted under MF scheme, free of cost, free of cost. Yes, madam. There's a delay of 6 years.
My lords, the delay of 6 years, my lords, because the first petitioner, that is respondent in the appeal, my lords, she died, my lords. Because of that reason, they could not initiate any action, my lords.
Who died, madam?
My lords, Moksha, my lords. Now the LRs are in brought on record, my lords, and they filed this petition, my lords.
When did she die?
My lords, I have produced a copy, my lords, that is 2021, my lords. Annexure F, my lords.
No, 5 ವರ್ಷ delay ಮತ್ತೆ. Yes, madam. Operation of the order dated 11/11/2016 passed the second respondent at Annexure D is state in the next date of hearing.
Please, my lords. My lords, the matter may be called along with another writ petition, my
Just
lords.
along with John.
Please, my lords, oblige me.
This one saying
Learned AGA for respond number 1, issue emergency notice respond number 2. Office objection overruled. Just after service of. Yes. 20 to 28. Till number 20. 20 ರಿಂದ 28 madam, same one. The entry model idea. Madam, what?
But when the matter is pending, it's the petitioner's family will not do not lack of then also then see the supporter
Allah, you are only possession. You're not the owner, you're only in possession of the property.
They are not the owners.
Still, you're not the owner. But then what is wrong with that? Reconveyance. Reconveyance. R3, R4 on the basis of sale deed. Sale deed ಆಗಿದ್ಯಾ?
ಅವರು ಓದತ್ತಲ್ಲ ಅವರು
Right. Ours ಇರ್ಬೋದು, but what is your right? No, what is, are you the owner? Where is the document? Possession is different. Are you the owner? I reconveyance Kata will be subject to the outcome of reconveyance proceedings. And unless you get a right, unless there is any semblance of right, you cannot challenge the Kata.
Even they are not the owners.
They are
Even they are not the owners.
Why their objection?
They are not the owners.
You appeal for? One. Notice to respond 3 and 4. List immediately after service of notice. Kata registered in favor of the respond number 3 and 4 is subject to the outcome of the petition. No, not for the. ಅಲ್ಲ ಇವ್ ಫೈಲ್ ಅಪ್ರೂವ್ ಎಲ್ಲ ತಾವು ಆಯ್ತು. We'll see after service of notice. Let them file statement of objection. Yes, yes, it is order. Then, yes, madam.
Serial number 10, my lord, for BBMP. Copy has not been served upon us, your lordship.
230.
Okay.
That is
Please,
the reservation matter.
please, my
230.
lord, please.
Standard AGF for respond number 1. Sharon Madhya Land Council access notice for respond number 2. This along with serial number? Along with 5 minutes. Here, what is the matter? Yes, you know about rain. Government Tilburg. Passport.
After pertaining to the CRS reservation numbered by 15250.
5250 of 2020. 10/8/20. Copy release again. Madam,
Serial 14 also.
Yogesh Naik,
Okay.
learned AGF for respond number 1. Yogesh G Naik, learned council access notice for respond number 2. This writ petition is filed challenging the notification dated 25/2017 issued by respond number 1, whereby insofar it relates to imposing a condition that the 5% of the total area shall be reserved as land bank for satellite town ring road project at the time of approval of development of the land, and the same shall be relinquished in favor of the satellite town ring road planning authority free of cost. The issue whether the petitioner whether the relinquishment of 5% of total area as a condition precedent for approval of development of the land was examined by the coordinate bench of this court in WP number 15250 of 2022. The coordinate bench of this court in the aforesaid case at para 5 so and so held as follows. View of the same. This writ petition requires to be disposed of in terms of the order passed in WP number so and so. Accordingly, I pass the following. A writ petition is allowed. The impugned notification dated 25/2017 issued by respond number 1 at annexure C insofar it relates to the condition requiring the owner of the land to surrender 5% of the total area in favor of satellite town ring road project at the time of approval of development of the land free of cost, and also the relinquishment date dated 37/2022. Madam, is registered as document letter executed by the petitioner in favor of respond number 2 at annexure D is held to be illegal and void and unenforceable. Copy to other in the same direction. Yes.
Serial number 14 also the same.
Same annexures.
Yeah, annexure, annexure. The 35/2017 notification is seen as annexure. Yeah, the serial number 14, madam.
Serial number 14, madam, instead of C, B.
And the relinquishment deed is at annexure C.
C.
And
Dated
the relinquishment deed is dated
I'm ready.
Ramaya,
Learned AGA for respond number 1 and 3. Issue emergency notice respond number R. Subramanya. Learned council accepts notice for respond number 2. The operation of the operation of the notice dated 28/6/2022 issued by second respondent at annexure F is stated. This is matter along with WP number 13450/2022.
The owner of the site number 15. After purchase, the accordingly first respondent has issued the e-kata, the server of the petitioner, and accordingly has paid the taxes and all. And thereafter, for the construction, he has taken the license from the first respondent, and also he has approved the construction plan. Annexure D is the license, and also he has taken the temporary.
Unauthorized layout.
But now we have issued the letter saying that the site has not been released, and also ordered for the demolition of the demolition of the property method. Annexure K page number 36 number.
Complete ಆಗಿದೆಯಾ?
Yes, my lord. The photographs have been produced, my lord, at annexure G page number 32, my lord.
Emergency notice respond 1 to 3. 1 to 3. The incident communication dated 22/4/2022 issued by third respondent at annexure K. State, however, the construction put up by the petitioner on the subject property is subject to the outcome of this petition.
Ramaya, number 70.
Imdala. 17. Learned AGA for point 1, 2, 3, 8. 8. Issue emergency notice 2, 4, 5, 6, 7, 9, 10, and 11. 11. Here, man number. After service of.
For more than 15 years, that license for connecting flags in personal subscribe under the government and structure. He was the license was directly every year, starting from March April 1st to March 31st. 6 months once that tax was paid. Yes, paid up to the date. And also this license has been
Only the notification inviting tenders.
It's auction.
Yes. Auction, other.
That's the question. Government itself has renewed its data. A connected B23, page number 9. This renewed for the year 2022-23. It ends with March 31st. Now from 110 onwards, they want another auction. There is no such practice at all. And I have given the license by 5% estimation for 22-23. It ends with March 31st. I have paid up to date. Now the option is big. No notice to me, no opportunity to me.
Current counsel for the petitioner submits that the petitioner has been interested to collect property tax for the period 1/4/2022 to 31/3/2023. However, which respondent? Our well issued the auction notice. However, the first respondent, without issuing notice to the petitioner, has issued a notice in daily newspaper for auctioning of
Collection of tax.
for auctioning of collection of tax in the bus stand. Fees for collection of fees taxes. Collection of fees taxes in the bus stand. So, issue major notice respond 1 and 2. Learned AGF for respond number 3. For the proceedings, in pursuance of the auction notice dated 14/9/2022, issued by the first respondent, published paper, just after service of Learned KV Gangadharappa, learned counsel actor correspondent, the operation of the impugned communication dated 30/10/2021, issued correspondent at annexure A. This matter along with WP number at another
Here, Mayana, it is Vivekananda.
Written by me. Shows that. Now, for the consideration purpose, the bare minimum is not required. The issue is very, very big. I have relinquished the certain part of the layout in favor of the MODA. Now, MODA has to give the ERDL. That is not the treatment of. So therefore, consideration of their absence is not completely of the.
ಯಾರು ಕೊಡ್ಬೇಕು ನಾವು who has to pay the amount?
MODA only has to pay. They can collect from the panchayat, but they have to pay. MODA has to pay because I have relinquished in favor of the MODA. Document is executed in favor of the MODA.
Alright, did they send any communication saying that till then you maintain ಅಂತ ಇದೆಯಾ ಅದು?
Annexure
Question? 2009 in the
ತಗೋತಾರೆ ಯಾಕೆ ತಗೋತಾರೆ ಇಲ್ಲ ನಾವು ಮತ್ತೆ ತಗೋತೀವಿ ಒಂದು ಲ್ಯಾಕ್ ಮೆಂಬರ್ಸ್ ಪೇ ಮಾಡ್ತಾರೆ ಅಂಡ್ ದೇ ಹ್ಯಾವ್ ಟು ಪೇ ಟ್ಯಾಕ್ಸ್ ಅಂಡ್ ಅದರಲ್ಲಿ CH-20 ಎಲ್ಲ ಮಾಡ್ತಿದ್ದಾರೆ
ಟ್ಯಾಕ್ಸ್ ಯಾರಿಗೆ ಕಟ್ಟಿದ್ದೀರಾ? ಮೂಡಾಗಿ ಟ್ಯಾಕ್ಸ್ ಅವ್ರು ವಾಪಸ್ ಕೊಡಿ. ಟಿಪಿ ವೇಕನ್ maintain the records ಎಷ್ಟು ಬೇಕಾಗುತ್ತೆ? Records ಅಲ್ಲ, where is the provision to collect money for maintenance of records? Is there any source of power? Maintaining records ಕೆಲ್ಲ ತಗೊಂಡ್ರೆ ಮುಗೀತಿನ. How much do you take? ಎಷ್ಟು ನಾಮಿನಲ್ ಚಾರ್ಜಸ್? What is the amount?
I have produced all the audited, totally, when the petition was filed, the amount claimed by me 1,17,49,000 as of the date of filing.
What is the amount property tax payable by you?
That is, I have produced the annexure, and annexure members, all members of the.
ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ? If you are not paid the property tax, then you are not entitled. If you have paid the property tax and plus you are maintained, then you are entitled for maintenance.
Your notification is the annexure D, where the property tax they have collected from all the members.
Just at the rate of? At the rate of?
What rate I have not mentioned, but the receipt issued by the Mudacho was 2014 ಅವರಿಗೆ about 6,860 for a site.
For each year? Per annum?
Per annum.
6,000?
6,816. So a little less because they have collected 2012 ರಿಂದ 2013 2 ವರ್ಷಕ್ಕಾಗ. So maybe 3,000 ಅವಾಗ 2014 ಅಲ್ಲಿ ಹೀಗೆ ಜಾಸ್ತಿ.
So I should come with the categorical statement. What is the property tax paid by you? Because if you are not paid the property tax, then you are not entitled. The law that till the layout is maintained by the local authority, you are exempted from payment of property tax because not providing any amenities to you.
They have taken all those ownership and they have sold the sites.
Plus, sold I said, yes, yes.
ಅವ್ರು ಕೆಲವು CH ಎಲ್ಲ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಅಲ್ಲೇ ಉಂಟಲ್ಲ.
ವಿವೇಕಾನಂದ.
ಪ್ರಾಪರ್ಟಿ ಟ್ಯಾಕ್ಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
Vivekananda, you should transfer it to the local authority. Then you should take action against through the government. Wait. One minute. Learned Council appearing for respondent number 2 submits that the second respondent has requested the fourth respondent to take over the layout in question. However, the fourth respondent, without any valid reason, is not taking over the layout in question and maintaining the same. Respondent number 4, those served with notice, has remained absent. Issue bearable warrant to the chief officer of the fourth respondent, town panchayat, returnable by 29. This is matter on 29.
Sorry. Therefore, the decision will be taken on or before 15 March, not having that on 16 or 17.
This is matter on application learned council for respondent This is matter of 16. ನೀವು ಅಪ್ರೂವ್ ಮಾಡ್ಬೇಕಾ?
ನಾವು ಅಪ್ರೂವ್ ಮಾಡಬೇಕು. ಅದು ಆಫೀಸರ್ಸ್ ಎಲ್ಲ
2017 ಶಿವರಾಮ್ ನಿಮ್ 22 ಒಳಗೆ ಅರ್ಜೆನ್ಸಿ ತೋರಿಸ್ತಾರೆ 2017.
ಕರೆಕ್ಟ್.
ನಿಮ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ಡೇ ಟು ಡೇ. When you appear for the petitioner 17.
ಇದು ಲಾಸ್ಟ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಇದೆ, ನಾನ್ ಅಥಾರಿಟಿ ಇದೆ.
ಅದಕ್ಕೆ ಹೇಳಿದ್ದು.
ಇಲ್ಲಿ ನಾನು ಎಲ್ಲ ಅಪ್ರೂವಲ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀನಿ. ನಾವು ಫೈನಲ್ ಲೇಔಟ್ ಪ್ಲಾನ್ ವಾಟರ್ ಹ್ಯಾಪನ್ ಅಲ್ಲಿ ಜಸ್ಟ್ ವಾಟರ್ ಕೊಟ್ಟರೆ ಕಟ್ಟಿದ್ದಾರೆ. ಅದು ಸ್ಟಾರ್ ವಾಟರ್ ಡ್ರೈನೇಜ್ ಇದೆ. ಅದು ಇಷ್ಟೆಲ್ಲ ಜಾಗ ಕೊಡಬೇಕು ಅಂತ ಹೇಳಿದ್ವಿ. ಮಾಡಿಫೈಡ್ ಪ್ಲಾನ್ ರೈಟ್ ಹೋಗಿ ಡಿಲೇ ಇಲ್ಲ. 17 we do not delay it. The case is different, this case is different.
Number 31, number 4.
Yes, madam. Yes, madam. What is it? Karnataka, yes. Yes, madam. Oh, senior, yes, madam. 5, madam, 5. Senior to be deleted. Yes, madam. This order to be read in conjunction with the order dated 26th August 2020. At request of learned counsel for phone number to list after vacation. What do you mean? Learned counsel for the petitioner has filed a memo for retirement seeking leave of this court, stating that the papers have been returned to the petitioner with no objection to engage another counsel, and the same is acknowledged by the petitioner. The learned counsel is permitted to retire from the learned counsel for the petitioner is permitted to retire from the case office to reflect the name of petitioner in the cost title list after vacation.
Matter will not where the direction is. Change of Kata my lord in respect of the property my lord pursuant to the sale deed executed by the BDA. Last 2 occasions my lord, my learned friend Sunil has appeared and he took time my lord. Now my learned friend has come up with another NOC my lord. Is the case where my lord? No. Including you are not suppressed any material fact.
What is the matter?
It's a case where, my lord, I have been the BDA has executed the sale in my lordship. He is none other than my brother, my lord, who is claiming that I am not the adopted son of Siddhaya. Therefore, Kata could not be changed. That's what I have taken the P&S certificate, your lordship. And accordingly, my lord, the sale deed has been executed in my favor by the BDA. Now I filed an application, my lord. Last occasion, argument now. This is the conduct of the invading applicant on changing the council after the council. He can't make them as a party. Why?
That to be registered is subject to the outcome
Yes.
of whatever.
Let them get it.
Also, not registered.
When see the noting of the corporation, you lordship. Corporation having said so to change the kata, but they issued a cyclostyle endorsement. Kate ಮಾಡ್ಕೊಡ್ಬೋದು, there is no interim order ಅಂತ ಹೇಳಿ ಬರ್ತಿದ್ದಾರೆ. There is an interim order application ಅಂತ ಹೇಳಿ. ಅದು ಆಗ್ಲೇ ಎಷ್ಟು ಸಾರಿ ಟೈಮ್ ಕೊಟ್ಟಿದ್ವಿ ನಾವು ನೋಡಿ. Let them educate.
Hearing ಆದ್ಮೇಲೆ ಮತ್ತೆ again it is not proper.
Compared to
come engage another council and seek for time.
That is the conduct of the party. That's why they
you challenge it. Have you got any order in your favor saying that you are the owner of that?
The adoption deed itself is a problem. So it is not.
He is based on a.
not this court jurisdiction, my lord, property situated in Bangalore, you obtain your money of PNDC or property.
It's also plain deceiver. Before the joint commissioner, very including applicant has made a statement that he has no objection to change the Khata. There is a limit for everything.
To file the suit what you have filed, to go obtain an order of injunction. Indian litigation, there is an order of injunction, restraint. In the absence of any order of restraint, is entitled. Convinced, but I take it.
This is seventh or eighth time, my lord, the matter is coming up and well, it is between me and the, if at all, if he has got any right, he said that he has got it, so file a suit and let him get it.
And all that, the petitioner subject to the outcome.
Yes, my lord.
You have already before making Khata, already the insurance supplement of state, we already filed a suit for to perform. Interim order there is that it is.
Interim order will operate.
That is the slogan, your lordship. They said that there is an injunction order, we will produce it.
I know, PNDC, when did you file revocation of that PNDC?
Even this is because they are not.
When ಯಾವಾಗ ಮಾಡಿದ್ದು? 2020, by this time, ಇವಾಗ ಆಗೋಗಿರುತ್ತೆ. By this time, it will have been over.
ಅವರೇ statement ಕೊಟ್ಟಿದ್ದಾರೆ, guide ಖಾತೆ ಮಾಡೋದಕ್ಕೆ BDA ನಮ್ದೇನೋ ತಕರಾರಿಲ್ಲ ಅಂತ ಹೇಳ್ಬೋದು. Report the joint commission. It is a frivolous application which has been filed. But all, if we have got any right, let him.
30th ಅಲ್ವಾ ಸರ್? 30th.
They will not be in stages. That's why it was got posted today, my lord. Number of times they have taken time, my lord. Really see the order sheet.
ಏನ್ ಮಾಡೋದು? This type of practice coming and filing.
That's why this court has to deprecate the conduct of the party, my lord, not the advocate. Conduct of the party should be deprecated and order has to be party, my lord.
Deprecate ಮಾಡಿ, then again have it on 12. It's not advisable. Not convinced Allah. The other council also tried to convince, I was not convinced.
You wanted to produce some judgment, you wanted to produce injunction order. How many times you have to produce the injunction order? They have taken several times. If he has got any right.
Ask somebody to represent 30th.
No. I know how many times my lord has to take up
This matter was heard on several occasions, and on the last date of hearing, see Sunil Rao, that council appearing for the proposed respondent, sought time to secure instructions and sought time to secure instructions and make submission. Today, ನಿಮ್ಮ ಹೆಸರೇನು? Today, KP Bhuvan Land Council submits that he filed for power on behalf of the proposed respondent after taking no objection from the earlier council. So the matter was heard at length, and at this stage, the learned council appearing for proposed respondent sought for time to produce
nothing wrong. Injunction article are here for
to produce relevant documents. The practice of entering appearance after the matter is heard, after the matter was heard at length, is condemned and deprecated. List this matter on 12.
that is your lord. I will ask my colleague to appeal.
Again, ಏನು ಮಾಡಕ್ಕಾಗಲ್ಲ. Yes.
I appear for the petitioner in this case, my lord. I filed withdrawal memo, my lord. I withdraw the petition as a not press.
Yes, sir. List on 12th, sir. List on 12th. Madam, serial number 32. 12th October. 12th October.
My lord, I filed the withdrawal memo.
Madam, wait, madam. No, your council filed a memo for retirement. It was accepted. Now I ask the registry to reflect your name in the causes and directed the registry to list this matter on 12th October. Yes. Learned counsel for the petitioner has filed a memo seeking leave of this court to withdraw the petition. Petition is accordingly dismissed and withdrawn.
Much obliged.
Hope to my client also. Instruction to go on with the matter because there are other dependents. Same concession will have to be extended to other ones.
The manner in which it was issued, was made submissions there and same day it was issued. Yes, yes. Your vendor is a party to this.
Now we have filed an appeal.
The model not operate against them.
It was passed against their vendor.
Their vendor. By that time, the land was already sold. Yes.
It was way back in August 2021, Indian model of December 2021. But the OS also was filed after the same. Therefore, I leave it to our, I would say this, if the appeal is accepted, I will obviously be bound by the outcome of the OS.
But let it be placed before the panchayat committee. That is the case. Otherly,
there is an order maybe about the sentence of you know, one says in after 24/12/2021, I think the panchayat is Samana Sarayati, certain number of over 1741 of the director
Then already construction has come up. Construction.
Construction again.
I guess
I cannot.
license for NOC for setting up a petrol bunk. And at this stage, the construction one would.
Otherly, there was an order from the Western Commission.
That affidavit will be placed on record saying that they will not claim any equity in case if they succeed in the suit.
There was an order from the Assistant Commissioner not to entertain any transfer in that particular layout. Despite that, this transfer is good. And without taking NOC, he has constructed.
AC gain power is to pass such an order.
Not provision. And revenue layout approved, that layout is not approved, but artificial entry. Despite that, still it is registered. And without NOC, he has completed the construction.
NOC is to store that explosive licensing. Store the petroleum products, you need NOC. That's like I need NOC from the local Gram Panchayat. Store that liquid, the actual explosive.
But even Panchayat has not stated that they have authorized the advocate to give such type of undertaking.
Right, and protect your right. Protect your right. ಮತ್ತೆ ಸುಮ್ಮನೆ ಹಾಕಿ ವೇಸ್ಟ್ ಮಾಡೋದು. Then again you have to file an affidavit.
The manner in which they did.
You file an affidavit saying that if you don't succeed in the suit, you'll compensate the petitioner respondent. Otherwise, you file an affidavit.
The manner in which they.
The manner in which even I
have done, it's not fair.
There is a respondent number 3 and 4 have been granted. Yes, yes. Oh. Agriculture land.
Land was acquired by the Maharaj in the 1959. Thereafter, industry was set up. There was no new cases. Case which conducted an auction. Subsequent project formed in there. Just until there is a conversion in the 1830s.
Again, let them place all the material before the panchayat. Not let the panchayat take it. The
user of land idu madre, it is for the assistant commissioner to take action.
But assistant commissioner has passed an order. I have produced the next week.
Ask him to go an application before the assistant commissioner.
But already there is an order.
ಏನಂತ?
Already Annex D ನಲ್ಲಿ ಇದೆ. This
They
is
are
passed
saying
on
that if an
6/7/2021.
application saying that without taking permission for diversion of land, they are utilizing it for commercial purposes.
The order is like this. 6/7/21 ಆದೇಶದಂತೆ ಅನಧಿಕೃತ ಬಡಾವಣೆಯಾಗಿದ್ದು ಕ್ರಯದ ವಹಿವಾಟನ್ನು ನಿರ್ಬಂಧಿಸಿದೆ. Despite this sale dated 26/8/2021 is executed. And added to that, they constructed the petrol bunk without NOC. Now,
Construction where building license ಇದೆಯಾ?
that is the reason, my lord, I requested them to file objections. Let the panchayat file objections. What is it? You hear a resolution for and 4 have filed objections. And panchayat has given this resolution copy.
Copy ಕೊಟ್ಟಿದ್ದಾರೆ objection. Objection ಇದೆಯಾ?
They have given only resolution copy.
Objection file ಮಾಡಿಲ್ಲ. Copy ಕೊಡಿ ಅವ್ರಿಗೆ. ನೋಡಿ ನಾನು I'll just dictate and have it on day after if you cannot convince. Yes. Respond. Point 3 and 4 were granted with license by the Union of India for setting up of petroleum outlet subject to certain terms and conditions. And one of the conditions imposed was that the said respondent should obtain no objection certificate from the respondent number 2, Gram Panchayat. The respondent 3 and 4 submitted an application with the second respondent for issuing no objection certificate. Since the said application was not considered, the respondent 3 and 4 were constrained to approach this court in WP number 659 of 2022. This court, by order dated 17th January 2022, directed the second respondent to consider the application submitted by the petitioner in person of stop. Second writ petition another.
First writ petition only 4 weeks time ತಾವು ಕೊಟ್ರಿ. Even before expiry of the 4 weeks.
Second writ petition ಇದಕ್ಕೆ ಹಾಕಿದ್ರೆ.
ಅದಕ್ಕೆ same direction. ಇವತ್ತು writ petition file ಮಾಡ್ತಾರೆ, ನಾಳೆ ಕೋರ್ಟ್ ಮುಂದೆ ಬರುತ್ತೆ, ಕೋರ್ಟ್ ಮುಂದೆ they will give an undertaking.
Again, the respondent 3 and 4 filed a similar writ petition before this court in WP number 3835 of 2022. The writ petition was disposed of by order dated 18th February 2022 on the submission made by the learned counsel for respondent number 2, stating that the respondents number 3 and 4 have deposited the sum of 50,000 and no objection certificate will be issued in favor of the said respondent on or before 21/2/2022. In pursuance of the order passed by this court, the respondent number 2 issued no objection certificate in favor of respondent 3 and 4 on 19/2/2022, against which the present petition is filed. Learned counsel appearing for the petitioner submits that the representation/application submitted by the respondent 3 and 4 was not placed before the respondent number 2, Gram Panchayat, and in the absence of any resolution passed by the Gram Panchayat for granting NOC in favor of the respondent 3 and 4, the impugned NOC granted in favor of respondent number 3 and 4 is contrary to the provisions of the Karnataka Gram Swaraj and Panchayat Raj Act 1993. Matte anything he further submits that suit for declaration.
Suit for partition.
separate possession is pending in respect of the subject property, and an order of temporary injunction is granted against the vendor of the petitioner.
Petitioner.
Vendor of the property. On the other hand,
Vendor of the respondent number 3 and
the vendor of the respondent 3 and 4. On the other hand, Vikram, who is good learned in a counsel appearing for the petitioner, respondents 3 and 4 submits that the subject property was purchased on 26/8/2021, and the suit for partition was filed on 7/10/2021. An interim order and an order of temporary injunction was granted against the vendor of the respondent 3 and 4 on 16. No. Against the vendor on Yes, on 16/12/2021, by which time the right over the subject property had accrued in favor of respondent 3 and 4, and in the absence of any order of restraint, the NOC granted in favor of the said respondent is in accordance with the provisions of the Act. So, there's a learned counsel appearing for respondent number 2 submits that only the resolution.
Page 6.
Submits that the representation submitted by the respondent 3 and 4 for granting no objection certificate was placed before the respondent number 2 panchayat on 10/2/2022, and the panchayat unanimously resolved to grant NOC in favor of respondent 3 and 4 as per the order passed by this court. And in pursuance of the said resolution, the NOC has been granted in favor of the respondents 3 and 4. I have examined the submission made well and come for the party. The order of temporary injunction is operating against the vendor of the petitioner, and in the absence of any order of restraint, the respondent number 2 panchayat has unanimously resolved to grant NOC in favor of respondent number 3 and 4 for setting up petroleum outlet on the subject property. The rights of the petitioner over the subject property is yet to be adjudicated by the jurisdictional civil court, and in the absence of any order of restraint, the NOC granted the respondent 2 has granted NOC in favor of respondent number 3 and 4, and the same cannot be faulted with in the absence of any. And the same cannot be said to be contrary to the provisions of the Act 1993. In the absence of any statutory violation in granting NOC in favor of the respondent 3 and 4, the present petition challenging the NOC granted cannot be interfered with. Accordingly, above the following, petition stand disposed of. The respondents 3 and 4 have filed an affidavit stating that undertaking that they will abide by the decision of the jurisdictional civil court in OS number 1747 of 2021, and in the event the petitioner succeeds in the said suit, the respondent number 3 and 4 shall not claim any equity over the subject property. And will deliver possession of the subject property in favor of the petitioner in terms of the undertaking affidavit filed by the respondent number 3 and 4 is placed on record. Ajit Anand Shetty, ಅಲ್ಲ? Ajit Anand Shetty, Land Council.
This stage, this stage, otherwise it will not work.
Submit that, yes. Undertakes to file power on behalf of respond number 2, lists this matter on service. Again, what is the matter about?
Ask for transfer of Khata in our name. Now the police write there is a inquiry, not the case complaint against my vendors. Was under the prevention of
You appear for respond number
planning of unregulated deposit schemes.
chief officer.
Now I am not allowed to even use the premises or the Khata is being paid. That's why we have filed an IA for direct.
There was question respondent
It can be heard.
without even acquiring at all. When we hear the representation of wild annexation to accident 85, it has not been responded to till now. If they give the necessary documents.
Yes, sir. It has to be heard, sir. It has to be heard. When do you want? ಅಲ್ಲ ನೀವು ರೆಡಿನಾ ಇಲ್ಲ you want to file statement of you have to file statement of objection. Let them file, sir.
In the meanwhile, we have got for implement on. Status code.
What is the status of the property?
Status quo all that we are.
Bark ಆದ್ರೆ ಏನು subject to the outcome of the writ petition ಅಲ್ಲ.
Make an observation that
ಆಯ್ತು. Any development over the subject. I am not passing any adverse order. I am not passing any adverse order. Any development over the subject property is subject to the outcome of the writ petition. Any development over the property in question is subject to the outcome of the writ petition. Learned Counsel appearing for respondent BDA, respondent BDA placed for time to file statement of objection. I'm granting time. Tomorrow you can argue on Rajakala matter. This is matter on Evag. Others after 17. In B group. Just to be heard. Notice of worker. Issue notice on I1 of 2022.
Hello, I am the owner of the property, having 10 cents of land, which is an area.
In fact, it is a lot of things I think. Or moreover, the user consensus pending to the benefit of the least power, we feel it is executed. As a consent, it is from court. While allowed to be included, I might take it to more.
This is only in respect of all. No, RTC entry is in my name, conversion order is in my name. There is a conversion order. NOC is being issued by the panchayat.
What is annexure section? What is the?
This is only for the purpose of collecting tax. I don't know that.
One nimisha, no, let him make submission. One nimisha. Alala, one nimisha. Let him. What is annexure?
My lords, annexure EA, where I made an application to issue form number 11B, is rejected by the Gram Panchayat, which is being approved by the appellate authority. Hence, I am putting this forward.
What are the ground for rejecting your application?
No, the ground under which my application is rejected is that the subject matter property which is purchased by me, it is the subject matter of the property which is a pending property which is being property in the partition suit which is being wherein finally it is drawn. That's what their contention. My submission before my lords is that, my lords, I have the owner of the property measuring 10 cents of land. The registered change is there. RTC entry was there in my name. Mutation registry is entered in my name.
The FTP. What has happened to the FTP?
My lords, a final decree is being drawn and execution proceedings have been initiated. Against the initiation of execution proceedings, one of the co-sharer has presented it and he has obtained input.
His name to be entered in property tax is subject to the outcome of execution. Nothing will happen. Yen agalla. There's a sale deed in his favor. The moment the sale deed is there, every right. When was the sale deed executed?
My sale is on 6/5/2013.
How is the consent decree?
My lords, the decree is passed by the first appellate before this court is on 29/1/2004. And commissioner has been appointed in a final decree proceedings is on 28/3/2008.
But consent decree is prior to your. The decree is prior to your sale deed.
Decree is prior to sale deed. What they say is that my property is subject matter of that final decree proceedings. In fact, it's actually incorrect. My lord, what I am saying is that what the appellate authority says that till date the property is not been identified in the suit. That's what the appellate authority has said. Kindly see.
Where is that consent decree?
My lord, the decree is passed on. My lord, kindly see. The first appellate order is on page number 94.
And final statement tomorrow at the work, maybe Friday, or be allowed to give back the record.
My lord, kindly see page number 95.
Entitled to 1/3 share in item number 1.
One of the A schedule to the extent of 14 acres of land after excluding the B schedule property. This is the decree passed by the first appellate court. Now kindly see, my lord, the final decree, the commissioner report at page number 97. Relevant is page number 98. Bojama is my vendor. Page number 98. Bojama is the vendor. My lord, kindly see F. Bojama. Bojama is my vendor. Now, my lord, this commissioner report does not reflect with respect of my survey number. My survey number is after coding 193/66 and 193/69. Now, appellate authority says that till date the property is not been identified. Kindly see appellate authority order. Page number 31. Page 31. ಈ ಜಾಗವು ಈಗಲೂ ಸಹ ಯಾವುದನ್ನು ನಿಗದಿಯಾಗಿರುವುದಿಲ್ಲ. My submission is that my property is not subject matter of the suit. Their contention is it is a part of the suit. Ultimately, property is not being identified as the view which is taken by the appellate authority. RTC stands in my name, mutation register, conversion order, no objections from the panchayat, everything is in my name. Simply because my lord, the property is being not been appointed.
The property is identified, you cannot object.
Anyway, my lord, suppose if a property is being identified, I'm sorry, if property is later being identified and it is found that my property is also included in the subject matter suit, why you have to be losing my time?
But I don't know in the year 1992.
Whether the property which is allotted to your share is identified by the commissioner. Court commissioner, where do we get that?
Oh, yes, one thing is identified. Then you can go out
Page number 91 is the consent decree. Page number 91. The consent inner page is 13 of the order of the law. If I look at the law, 5 lanes. Those there have been told to be expected while advance they are submitted that they would be satisfied with the other two branches naming to the law. And they have no patient many this is item from where I have passed here 964. But when it comes to the commissioner's report, when it comes to the commissioner's report, I directed page 96. But I have passed in 96, 964, 14 acres of land. I am going to partition. When you get this paragraph, page 98.
A, B, C, F.
These are the even Bojamma is well done. Lord,
F only. Bojamma, Rajaman, there is father so and so. They have remained so that shown in the cover.
Lord, kindly come to D. There are D. Lord, there is a finding by the commissioner that my lord, they have sold more than what is not allotted to their share, but allotted to their something like that.
Including the area of 8.55 acres, the defendant respondent and their mother Janaki and father also have sold 6.0. This is seen by purchase deed so and so. Namale, what is the extent you purchased?
My lord, I purchased 10 cents. Page 103, the commission report is submitted on 28th of the May. I have purchased in subsequently 2013. Page 103.
But therefore, they are sold and now processed by so. That is 15.27 acres. I look at our gates, page 99. 15.27 acres, that is to say 1.27 acres more than what is their share. Now, apart from there, they have sold 2 acres. But it's my property. But they have already sold more than what is required. Or their share. But thereafter, now there is execution proceedings pending. One of the reasons I have mentioned is right in the background. Since 1964, what I have not given the usual. When you look at execution proceedings, now it's at last like Lord. Now it is coming. This order is passed in the year 2020. Now it is coming for.
What is the president going to be cost?
How is it? Or we should make out a case for man.
Now it's a disputed question of fact.
On the basis of illegality, can he claim a mandamus?
He's got a registered sale date. Registered sale
I have
date.
a court degree. I have a consent degree.
But
We are
it is
going on selling the property. We are going on selling the property. There shall be some shop for some
Unless it is-
of the court.
according to it, is still not part.
This aspect for a look at the prayer. Still, there is a who passed the order of the appellate court. Appellate court has not passed any order. Appellate court has deferred the matter. Or he is keeping a mandamus. Where the appeal is pending. Second, look at the first prayer. Whether he is entitled.
What happened to the appeal?
Appeal is deferred.
Deferred.
Appeal deferred. Appeal ಯಾವ the reason is page number 31. ಘನ ನ್ಯಾಯಾಲಯದ ಪ್ರಕರಣ ಇತ್ಯರ್ಥ ಆಗುವವರೆಗೆ. Page number 31.
Consider your submission. I will consider. I am not passing any orders. No. I know. Yes, yes. First, I want to find out what is the order passed by the appellate authority. Allow me to ask him what is such a big.
Page number 31. ಸದರಿ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಘನ ನ್ಯಾಯಾಲಯ ಪ್ರಕರಣ ಇತ್ಯರ್ಥವಾಗುವವರೆಗೆ ನಿಮ್ಮ ಕಕ್ಷಿದಾರ ತೋರಿಸಲು ಒಂದ್ಸಲ ತೋರಿಸು ಆಸ್ತಿಗೆ 9 ಮತ್ತು 11B ಅರ್ಜಿಯನ್ನು ವಿಲೆಗೆ ಕಾಯ್ದಿರಿಸಲಾಗಿದೆ. That means dispose of.
ವಿಲೆಗೆ ಕಾಯ್ದಿರಿಸಲಾಗಿದೆ for dispose of. It's pending.
Then my not original authority passes.
Abeyance. Kept in abeyance.
Page number 33.
The motion must pay. Direct the point to the appellate authority. And I will very official that. Let's see. Finally, the time for when.
There is no order passed by the appellate authority. It's kept-
Original authority rejects my application.
The original authority, now the appellate authority is not passed, by, kept it appeal in abeyance, subject to the, I'll direct them to consider independently and pass order. And you go file your objection. I said this. Unnecessary arguments like a simple like 5 minutes, so only case. Mandamus Allah, yes. Because you are appearing for the response, tomorrow when you appear for the petitioner, you will be seeking mandamus. Petitioner claims to have purchased. Petitioner claims to have purchased the property bearing number.
Bearing survey number.
Survey number 193 bar
measuring 5 cents.
193 bar 66 measuring 5 cents.
And 193 bar 59 measuring 5 cents. In total.
And 193 bar 59 measuring 5 cents. Totally measuring 10 cents. Situated at the Shettigiri village, Virajpet Taluk, by virtue of a registered sale deed dated 6/5/2013. Full stop. Petitioner further claims that in persons of the sale deed, the name of the petitioner was entered in the revenue record, was mutated in the revenue record, and also he was permitted to divert the land for residential purposes.
Conversion order.
Permitted to divert the land for residential purposes.
Yes.
Under section 95 of the Karnataka Land Revenue Act. Full stop. Exactly. Then thereafter you submit an application with
When the NOC has been issued by the panchayat
for
for converting the land.
NOC Allah.
No objection. No objection.
Thereafter, he submitted an application with the respondent number 1 to enter his name in the property tax register maintained by the respondent number.
Page 179 is my application.
Property tax register, 11A. Property tax register maintained by the respondent 1 panchayat. Full stop. The said application came to be rejected, stating that there is a dispute pending in respect of the subject property against which the petitioner filed an appeal before the second respondent. The second respondent by impugned order kept the appeal in abeyance, saying that the
Page 31 is the finding.
stating that the subject property, stating that the property is in question is a subject matter of dispute, and the application and the appeal and the appeal cannot be considered till adjudication of the dispute in question. Full stop. Against which the present petition is filed. Learned counsel appearing for the petitioner submits that the petitioner having acquired right title over the subject property by virtue of a registered sale deed is entitled for entering his name in the property tax register maintained by the first respondent as specified in the tax rules. What is that?
So there will be for collection of property tax.
Audit and tax rules.
Panchayat Raj budgeting and accounting rules. Sir.
Panchayat Raj
budgeting and accounting rules.
Accounting rules. So when it submits that the impugned endorsements issued by the first respondent as well as the order passed by the second respondent is contrary to the provisions of this set rule. On the other hand, the learned counsel appearing for the proposed respondent submits that the subject property, the properties in question, the subject matter of submits that the proposed respondent has acquired title over the subject property by virtue of a consent decree passed in OS number passed in OS number,
RFC,
RFL or OS.
OS this is I know, RFC दिख रहा है,
In our RFL number,
RFC number
2048 of 2000, and the decree obtained by the proposed respondent is prior to the sale deed executed in favor of the petitioner. The petitioner is not entitled for entering his name in the property tax registered by the first respondent. Examine the sufficient waiver learned counsel for the parties. The second respondent has kept the appeal in abeyance till adjudication of the dispute in respect of the subject property on the ground that subject property is not identified. Or
ಇಲ್ಲ ಆತರ ಬರ್ದಿಲ್ಲ.
property
Finding is ಜಾಗವು ಸಹ ಈಗಲೂ ಸಹ ಯಾವುದನ್ನು ನಿಗದಿ ಆಗಿರುವುದಿಲ್ಲ.
On the ground that the share allotted in favor of the proposed respondent is not identifiable. That's the only ground, and the same, and the appeal filed by the petitioner can be adjudicated after disposal of the execution proceedings. After adjudication of execution case number 59 of 2011. Stop. The second respondent instead new party is rally.
No, they were not party before the appellate authority nor before the original authority.
Stop. There is a dispute with regard to title over the subject property. There are private claimants to the petitioner as well as the proposed respondent are claiming the right over the subject properties by virtue of a registered sale deed executed in favor of the petitioner and the consent decree passed in favor of the proposed respondent. It would be appropriate if the second respondent, after hearing the petitioner as well as the proposed respondent, passes an order in accordance with law after providing an opportunity. Hence, it would be appropriate to direct the second respondent to reconsider the appeal afresh filed by the petitioner after providing an opportunity of hearing to the petitioner as well as to the proposed respondent. So accordingly, I pass the following resolution. Is allowed the impugned order, allowed in part the impugned order dated 7/1/2021 passed by the second respondent in appeal number
852.
order dated 7/1/2021 passed by the second respondent and Annexure A is hereby passed. The second respondent to reconsider the appeal filed by the petitioner afresh and pass appropriate order in accordance with law after notifying the petitioner as well as the proposed respondent. Full stop. The said exercise to be concluded within a period of 3 months from the date of receipt of the certified copy of this order. All contentions are kept for the mutation raised on the mark.
Maintaining the petition to be allowed. That amend my concept.
Madam Mother, heard on IA1 of proposed respondent better, respond number 3 on the money. Heard on IA1 of 2022. Considering the reasons assigned in the application, the petitioner who claims right over the subject property by virtue of a consent decree is a proper and necessary party. Accordingly, IA1 of 2022 is allowed. Petitioner proposed the applicant is permitted to come on record as respond number 3. Petitioner counsel to amend the prospect.
Permitted to amend.
A numbers? A is what is the matter?
2 of 22 and 3 of 22. Payers are not against my land, but we are done, but they are 20 on 23rd October.
For direct supply water. What is the matter?
Petitioner, number 1 is an association of owners. This number 2 and 3 after amendment have been included, they are owners of the association. There is a layout called as Dwarkamai layout.
What do you want? What is that?
Hand over the common areas and the park areas to them.
RMP 2015 regulation number 7 permits and this is judgment of this honorable court. And I was constrained to ask for this because there was direction was there by this honorable court in 2019 to BPMC WW to maintain the layout. Now, my lord, they have not done anything. There are multiple letters sent by me which are a part of the record. This is a layout developed by respondent 7 to 9, my lord. What they do is, even today, in 2007, there is a notification which I have produced, I will point out. There it says that the common areas will rest with the state. Despite today, the builder has put a board there that he is maintaining the layout. Entrance of the gate is, layout is.
The road, park, open spaces are relinquished in favor of the local authority.
Yes, my lord, they have been relinquished. No, they have locked the gate. If I go a bit late in the night, the builder does not allow, there are security staff deployed with it. Maintenance of the layout is not done by the builder. Our builder says, I want to maintain even now after vesting and demands maintenance at 50 rupees per square feet of the built up area, which comes to about, all villas put together to come to about 25 lakh rupees a year or something. We, under the same.
Residential layout or a?
Residential layout, villas, 25 lakh villas are there. No,
common, is there any amenities provided you by the builder?
Well, our builder is claiming that he's still giving the amenities.
What amenities? Amenities like?
Well, one security is provided at the entrance of the layout. The security is blocking my entrance and entrance of relatives who come to meet me. There is a sewage treatment plant. As I am saying, I have formed an association of owners of about 13 owners in 2017.
Then gated community.
Other now.
Security.
Access for the people, this is being monitored by the legal. Absolutely, there is no problem as such. In fact, when they gave a complaint to me, saying that they are closing the entire gate, so I went and they are wanting to open up also. There is absolutely no problem. I don't know what is the difference of my
I'll find out. I'll find.
Certainly, it's not the RFP. But it makes it very clear that in which event I take the decision, I have to hand it over. But absolutely no such representation is given to me. Consider that.
Now that the open space park is vested with the local authority.
I'm not particular that this leaf is to be given, my lord. I will just take about 5 minutes to explain what is the grievance. There is an order passed by this honorable court, my lord.
What is the prayer? What is the prayer you are seeking for?
My lord, repetition and arrested extradition, my lord.
Page 30, direct to make necessary to supply water. Main prayer rather. To hand over the maintenance management to the petitioner.
I'm for petition association and
under what provision are you seeking this?
My lord, RMP regulation 7.
Where is it?
My lord, I have not produced a regulation, I have produced a judgment of the honorable court which quotes this regulation. Annexure B page. Annexure B page 179.
Yes, what is this?
7.1 says.
My lord, it is there at page number 205.
7.1.1 says 10% of land shall be reserved for park and open space. The open space that is park shall be relinquished to the authority free of cost, and the same will be allowed to be maintained by the local residents association registered
is the authority so disaster. That means it is for me to take a call.
Discretionary.
Discretionary.
My lord,
I may be allowed.
you make a representation with the respond BBMP.
My lord, fair enough, my lord. I may be. My lord, if my lord friend allows me to talk, I will talk.
No statute right.
My lord, I may permitted to make submission. My lord, the problem is, this is a association. There is a report filed in this honorable court by ASPCB. The SPP, my lord can take it and file it along with the memo. What they have done is, my lord, that they have maintained an SPP. The SPP.
Mr. Sikar, limited prayers to hand over the open space parks to the petitioner association for maintenance in terms of regulation 7.1.1. And it is discretionary. It says may at the discretion.
Yes, my lord, I agree.
Confine your argument.
My lord, I agree. No, that's why I have to point out, my lord, I am in an unenviable situation where this honorable court in 2019 directs BPMP. My lord can see annexure V order. My lord can see the order is followed. Very briefly, I'll point out, my lord. The association says the builder is causing problem. SPP in the CH is being directly elected to drain. Therefore, let BPMP take over the layout and maintain the layout. 2019, an order is passed by this honorable court. March 2020, the comment remove the gate. September 2021, the builder again puts the gate. Nobody is being let in. BDA does not come inside the layout.
That is not the subject matter of the writ petition.
Like e-writ petition.
E-writ petition.
Oh.
E-writ petition only you're seeking for a direction.
ನಾನು ರೀಸನ್ ಹೇಳ್ತಾ ಇರೋದು ನಾನು BDA ಅವರು ತಗೋಬೇಕು ಅಂತ ಯಾಕೆ ಕೇಳಿದೆ ಅಂತ ಐ ಆಮ್ ಟ್ರೈಂಗ್ ಟು ಎಕ್ಸ್ಪ್ಲೈನ್ ಓನ್ಲಿ ರೋಡ್ ಇದಕ್ಕೆ ಲೇಔಟ್ ಒಳಗೆ ಎಂಟ್ರೆನ್ಸ್ ಕೊಡ್ತಾ ಇಲ್ಲ ನಮಗೆ ಅಥವಾ ರಾತ್ರಿ ಹೋದ್ರೆ ಬ್ಲಾಕ್ ಮಾಡ್ತಾರೆ ಐ ಆಮ್ ಎ ರೆಸಿಡೆಂಟ್ ಐ ಆಮ್ ಒನ್ ಆಫ್ ವಿಲ್ಲರ್ಸ್.
That is not the subject matter of the petition. Writ petition is confined only to handing over of the part.
I am explaining the reason why I am asking this. On the one hand, BBMP has been directed by this honorable court. BBMP does not do it for 3 years.
Confine your argument to the prayer made in the writ petition, not beyond that.
Not beyond this, but I want to explain.
Whether it's allowing or then it's a matter of go file a suit for injunction against the builder.
My lord, all I am saying is why I am constrained to make this prayer is despite the direction by this honorable court, BBMP is not maintaining the layout.
That is why
he pray my lord.
Have you given a representation to the respond BBMP saying that you're not making the part?
No, I point out, my lord, I have produced it on the card. So, my lord can take 7 annexure B, page 172.
Commissioner Health so take over of Dwarkanath by BBMP. Take over anta helidare, not hand over anta illa.
Illa adre alla ನಾನು ಹೇಳ್ತಿರೋದು ಯಾಕೆ ನಾವು ಹಾಕಬೇಕಾಯಿತು ಅಂದ್ರೆ my lord can
not getting my point. Have you represented the BBMP to hand over the maintenance of the parks and open space? Then you make a representation, then I'll direct them to consider. There should be a demand made by you first. Then only I can. No, sir, will not go beyond this. If he makes a representation, consider in terms of regulation 7.1.1. Format, prescribed formats.
My lord.
Ninth, you file a representation, file an appropriate application before the BWSSB for supply of water. The same will be considered in terms of the regulation. That can be done.
My lord, I will do that, my lord. In the meanwhile, I'll request for some interim protection in the
No.
My lord, no drinking water to me. BWSSB has filed objections.
You file it by Saturday. I'll ask them to consider within 3 days.
Yes, my lord. Yes, my lord. We will do that. I will do that.
There's some issue is to resolve it because all this engineer that represent solve.
I tell them to grant liberty. If you consider their application in terms of the regulations.
Yes, my lord. I will do that. A time frame may be for that, my lord.
Difficulty, you consider and issue an endorsement.
There is a difficulty in that particular area. But the various levels are different.
Well, there I have advised, my lord, we will pay. My lord, there we will bear the expenses. That's not a problem. There we will bear the expenses.
Petitioner, here what you want to make, I'm only direction, granting liberty, that's all.
This decision has to be taken, whether to hand it over to them or not. Each over as a registered association is
Other than all.
registration regarding the direct notice form. It is a separate petition. Emergent notice is issued by this court. That when registration is under challenge before this court, Lord, I can't take a decision. This is what I want to bring to your.
There is no order of restraint, there is no order of
There is
stay.
no order of restraint, but that is not the registration is not in the challenge.
If the matter is kept pending for 10 years, you cannot deprive them of the.
I don't have notice.
I tag this matter along with the WP.
Your lordship may dispose of this matter. My lord, because my situation is this. There is
Consider in accordance with law. I'm not saying you go. In terms of regulation 7.1.1.
Because Grievance will not allow to assign Grievance just why
Yes, yes, they are different.
my lord, my problem is I am in an unenviable situation where I don't have drinking water. No Civic. STP is there, it's under their control. I am remedying that.
Number one, claims to the registered association constituted for the purpose of welfare of the residents of the layout in question. Villas in question. Petitioners number 2 to 5 are the owners of the villas in question. So petitioners are seeking for a issuance of a writ of mandamus directing the respondent number 3 to hand over the maintenance and management of civic communities and common areas of the layout to the petitioners. Stop. Learned counsel appearing for the petitioner submits that in terms of regulation 7.1.1 of the revised master plan 2015, the petitioners are entitled for maintenance and management of civic communities and common areas. Hence, he submits that the respondent number 3 BPMP, having not maintained the civic community and other common areas, the petitioners are entitled for maintenance of the same. On the other hand, learned counsel appearing for respondent number 3 BBMP submits that the direction cannot be issued to the respondent number 3 in the absence of any representation made by the petitioner for handing over the maintenance of the common areas as well as civic community. Therefore, it is expedient. Further submit that the registration of the petitioner number 1 association is subject matter of WP number 16 to 88 of 2022. Hence the relief sought for in the petition. Hence the petitioner is not entitled for the relief sought for in this petition. Learned counsel appearing for respondent BBMP, BWSSB. Respondent number 5 submits that the petitioners have not submitted an application in the prescribed format so as to consider their claim for supply of water, sewer connection as specified under the regulation. As specified under the provisions of the BWSSB Act. and regulations frame thereunder. So in the absence of any demand made by the petitioners, the relief sought for in the petition cannot be granted. Therefore, it is expedient to dispose of the petition, granting liberty to the petitioners to submit an application with the respondent number 3 BBMP for handing over the civic community and common areas in the layout in question. And if such an application is submitted by the petitioner, the respondent BBMP to consider the same in terms of regulation 7.1.1 of the RMP 2015 and pass appropriate order in accordance with law. Pass approved order in accordance with law within a period of 6 weeks from the date of representation to be submitted by the petitioner. Similarly, the petitioners are also granted liberty to file an appropriate application in the prescribed form with the respond number 5 for supply of water and sewer connection under the provisions of the BWSSB Act and rules made thereunder. Such regulations made thereunder. If such an application is made, submitted, the respond number 5 to consider the same in accordance, consider the same and pass appropriate order in accordance with law within a period of 4 weeks. ಎಷ್ಟು ಸರ್ within 8 weeks from the date of within 8 weeks from the date of representation to be submitted by the petitioner. So, petitioner's respond number 5 is the liberty to file an application for extension of time if required. 8 weeks. 8 weeks. All 8 weeks. ಏನು ಮಾಡಕ್ಕಾಗಲ್ಲ. ನೀವು ಆ ತರ ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಕೊಡಿ ಸಬ್ಜೆಕ್ಟ್ ಟು ದ ಔಟ್ಕಮ್ ಅಂತ. Pending IS does not survive. Copy 6 ಅಲ್ಲ 30th ಇಲ್ಲ ಮೇಡಮ್ 30th
Out of turn, may I mention?
Yes, there is, sir.
Serial number 44, further dictation. Stay may be.
Yes, sir.
Stay may be.
at request of learned counsel for respondent number 1. Yes, this matter after 70. Interim order granted. Yes, yes. Ragata Shivaram, 2:30 I got reservation matter.
Here council agrees by my proposal, it will be done within 5 minutes.
KRC mundu let them hold an inquiry within a time.
Inquiry model different issues will happen. The amount of energy which we supply to the grid, the amount release model. What they said is will
direct the commission to conduct an inquiry as to the quantum of electricity which is generated.
Oh, that is very relaxed. It is they have produced. My learned friend took time a lot to file objections to the document which I have produced. The energy which has been brought to the notice of some about by filing documents. It is agreed. It is a 41/27 application act. They wanted to file objections. Yes.
Yes, yes.
State's capacity is not. Because there are power purchases. There is 100 unit of electricity not that is generated, for which there is lot of the generated. But it is divided in all the distribution licenses. For example, not this case, it's not in this case. Its portion is 25 units. Then I have to consume 25 units, I have to sell 25 units. I have to recover that through distribution from consumers. This is the process. Now, if there is more energy which is coming into the grid, but which is not utilized by me, what he is now saying is I have generated. It has gone to the common pool of the state. Therefore, you pay. But I have not recovered that. Therefore, I had this submission many months back. Say, for this, the SIDC says that bigger reading is there, but I have not allocated this as part. Some mechanism or commission has to say if they have to get power. Problem is he has dragged it from 2019 till today. He doesn't say power purchase agreement. On the premise that we have to get a higher tariff. Commissioner has told him please come and find calculation. He does not do that. Without contract, there is a prohibition in law that I cannot pay. I cannot take power, I cannot pay. 86B.
That dimension grid lock ಮಾಡಬೇಕಾಯ್ತು.
I cannot lock.
I don't know.
I had to take it plastic. What happens nowadays?
Now that wrongly have allowed him to generate. Lock ಮಾಡಬಹುದಾಗಿತ್ತಲ್ಲ. Because in under your.
But I ultimately not took the drastic step of disconnecting the entire system.
Instead of that, ಅದು lock ಮಾಡಬಹುದಾಗಿತ್ತು.
Selection movement, it will have been done long back.
Now being like.
The drastic step. Last step not is to.
The only question is who has consumed the electricity.
Karnataka Power Corporation itself has given the invoice for kindly seen not by me. Meter reading though, that has been supplied to them and meter reading is there.
Electricity into the grid.
Yes, Lord.
Who has consumed it? That inquiry has to be done.
That is inquiry already law. That is state, it is under the control of state SLDC. SLDC has produced that details, Lord. And annexed art in the annual accounts meeting.
Who has consumed? Who has consumed the electricity?
That is the SLDC has to say, your lordship. SLDC has to say. Who has to say? All these times, Lord. All these times, their contention is that they are not supplied, they are not received. Now, after producing the document, they say, who do not know who consumed it. Then who is answerable? SLDC was made as a party. To appear, I produced the document. It is SLDC who has to answer who consumed it. I have supplied to the grid. You said that they are not supplied to the grid at all. That is not their contention.
Matter request consideration.
Consideration. ಇಲ್ಲಿ similar ಬೇರೆ ಎರಡು ಬೇರೆ ತಗೊಂಡ್ಬಿಟ್ಟಿದ್ರು
ಆಗಲ್ಲ ಬಿಡಿ.
ಅಲ್ಲ
No, it is not possible.
ಅಲ್ಲ,
20 I got back.
what I am submitting to you also is power purchase agreement ಅಲ್ಲಿ ಒಂದು tariff ಅನ್ನ ನಾವು enhancement tariff ಕೇಳಿದೀವಿ ನಾವು. All right, you cannot pay it unless I sign the renewal agreement ಅಂತ ಹೇಳ್ತೀರಿ. All right, agreed amount ಏನಿದೆ ಅದನ್ನ ಕೊಡಿ, supply ಮಾಡಿದ್ವಲ್ಲ, that's what I my request. Rest of the things I will go knock the door of the KERC, that's what I have been making sufficient. Kindly see the tariff, the KERC letter itself, my lord. KERC letter. I will clarify that you will not. KERC, what I clarify, KERC has said. It has not closed the supply of energy. My lord would get it, my lord. KERC. Kindly see, my lord, annexure U, my lord, for a moment. Annexure U, page 89. My agreement become merely because I have not signed the renewal agreement, that will not take away the effect of earlier agreement to supply the power at the prevailing rate, will ask. Kindly see, my lord. I read two paras, will ask. On a detailed examination of the terms of the MOA, my lord, that is second para. Other page, annexure U, page 18, my lord, in the petition number, what petition, my lord? 347. The disconnection which they now made, my lord, they would have done it in 2018 itself. Page 18, my lord, 89, annexure U, my lord. Annexure U, this is the KERC letter to the general manager, managing director of the CHS. The renewal of MOA between CESC, Mysore and the NERA project, so respect of 0.5 megawatt renewal and so on so. Please refer to your letter cited under reference wherein you have sought approval for the renewal agreement dated executed on 16/8/2018 between the CESC, Mysore and the Sai NERA project petitioner private limited for a period of 5 years starting from 2/9/2018 under the provisions of 9.11 of existing MOA executed with them on 17/7/2012. The base is 17/7/2012, my lord. That has not been stopped at that, my lord. For 5 years, close agilla. It is continued. Next, on a detailed examination of the terms of the MOA contained in Article 5.1, Article 19.9.11, it is inferred by the Commission that in order to incentivize the mini idle generator to sell energy to the CESC, Mysore, for a period of 5 years from the date of the COD, the tariff of 2.60 per unit prevailing APCC rate for 2012-2013 financial year and for the subsequent financial year at the APCC rate as notified by the Commission from time to time was allowed. As compared to the prevalent generic tariff, rupees 340, my lord, may kindly note this, your lordship, per unit at the time of commissioning of the subject project, apart from allowing the benefit occurring to the generator by selling the RECs against the idle energy generated by the Sai NERA Power Project Limited. Next, my lord, may kindly see. However, the prevailing generic tariff for the mini idle project is rupees 3.95%, 9.5 rupees per unit, as compared to then prevailing generic tariff of rupees 3.40 per unit and the APPC rate, which is currently at rupees 3.64 per unit, is likely to go up in the coming years as compared to the APPC rate of rupees 2.60 per unit for the financial year 2012-2013. Therefore, the Commission considers that there is need to COP tariff in the instant cases at rupees 3.40. My lord, may kindly see, my lord, this is the letter of the KERC, and my lord, there is tariff in the instant case of rupees 3.40 per unit, being the then prevailing generic tariff of the mini idle projects or the APPC rate, whichever is lower, by suitably amending the Article 5.1. With this arrangement, the generator is assured of generating tariff prevailing at the time of commissioning the subject project or the prevailing APPC, whichever is lower. The Commission is also of the view that the Article 19.11 or the MOU should be amended to specify the provisions of renewal or further period of 5 years and on such terms and conditions as may be mutually agreed upon. Well, I will kindly note this, Your Lordship. I am asking for some extra amount. It could be mutually agreed. Provided, apart from that, the prevailing rate of rupees 3.40 should continue till I am going to agree for the settlement for renewal of the agreement. Well, that is the summons substance of the letter and the communication issued by the KERC itself. Further read, Your Lordship. It specify the provisions of renewal of further period of 5 years and on such terms and conditions as may be mutually agreed upon between the parties, subject to approval by the Commission 90 days prior to the expiry of the said period of 5 years. Accordingly, I am directed to inform you to advise the generator about bringing in these amendments, including other necessary amendments, which are closed at once. Thereafter, I submit a revised renewal agreement. This Commission, my lord, did not take away the effect of previous agreement. So what the Commission says is, unless till I come to a conclusion or final rate with the mutual consent or with the negotiation or something, the whatever existing rate available as on the date of renewal of the agreement, that should prevail. That's what they say. And accordingly, I am demanding whatever supply which I have given, you pay it. Rest of the amount I will negotiate with the KERC. For everything, I cannot knock the door of the Commission. Why I should go? I can understand by virtue of this letter.
Communication.
This
KERC
communication is 3.40 per prevailing rate. That's what they say.
Till the tariff is payment of tariff is fixed, then he is entitled to supply generate power at the rate of 3.4 per
prevailing rate.
No, till the contract is signed.
Contract is signed. That's what they say.
Till the contract is signed.
Unless he signs a contract, I either get the power, or I can pay anything, or I can claim it as a pass-through in my time. That is the whole problem. Now, Lord, I can show innumerable letters written to him, saying that please come and sign the contract. In the same compilation, Lord, page 93. A letter in 2018 written to him by the other party to the contract, say that
I have answered to that. I have answered to that letter. I have answered to that letter. Subject to
page 97.
ultimately, it is a matter of negotiation and understanding.
Or madly, Shriram, or madly.
It is February 2019 again, we told him to execute. Contract. He doesn't want to do it. He says that I am not going to execute the contract for various reasons. Then not page 100. According to the above continuation of all these letters cited at reference number 9, I am directed to inform you that since you have submitted your conditional consent for execution of the renewal agreement, and that conditional consent renewal agreement cannot be executed as the same as to be mentioned. Renewal agreement access also to execute the renewal agreement only if you receive consent letter without any conditions. Further, for disputes, if any, on any issue, the renewal agreement, you can always approach the KERC. Then KERC not to page 101 writes to him and says that if you have any grievance, you file an appropriate petition. That would have been not you have availed actually, so that it would have been resolved once and for all. So far as page 89 is concerned, when we went for agreement, admittedly not, for all these agreements have a control period. The period is 5 years. It comes to an end. Before that agreement comes to an end, this process of renewal has to commence. It's staying. But he was not ready for that time. But why not? I did not disconnect it at that point in time. But ultimately, not using natural resource. This is a mini header. But I can go and disconnect as I have done. But not the water in that panchayat will flow, which he will not be able to generate, or will anybody else will get the benefit of that. Therefore, that's why I said, it's a very drastic step that I have to go disconnect, because he left me with no other remedy but to disconnect it, which I had to correct everything and ultimately disconnect. Now, Lord, in such situations, when Lord, he doesn't want to sign a contract, but he wants to dump power into the grid. But I have produced judgments which have considered this aspect. It's not a novel situation. Where not people have come before the regulator and not the appellate tribunals and said that now that I have dumped power into the grid, where is it? Then the question not is, are they entitled? Because if this is considered as an illegal injection of power which is prohibited by the grid code, ultimately not grid code says grid safety is the paramount importance, because without scheduling, please don't put any energy into the grid or remove any energy into the grid, because the grid cycle has to be maintained at 57 plus or minus 1%. Now, not SLDC's job is to see how many units are being generated, how many units are being consumed. Now, if this matches into that 50 cycles, if generation goes down, then it becomes negative. Then what instruction is given for thermal plants, but nuclear plants to say please increase generation so that the frequency goes up. On the contrary, if consumption drops, but I have to say, tell all these firm powers to reduce. This is the process that is followed by executives. Now, Lord, if he dumps power into the grid without schedule and says, I don't care about you, I don't have a contract, I don't have schedule, but I will keep on pumping power into the grid, not it's a problem to the grid. Therefore, for grid safety not, commissions and regulators and the appellate tribunal, I have although it's not binding on this one, but on the regulatory side, both has been understood, but I have produced judgments. Say that if we
now that
legally
the power which has been generated has been consumed.
No, it's not consumed by me.
No, by someone.
I don't know.
We don't know. That is the inquiry.
Unless commission says that, okay, I will approach the amounts on the escrow and at this rate you have to pay, they will not permit me to collect it from anybody. Therefore, I am out of pocket. I am already not in great financial difficulty. This will be a burden.
Which is this commission?
Here.
Yes, Allah, Nimdu.
That's why I suggested.
Chamundeshwari. Which commission? It may be a MESCOM or ESCOM or anybody.
Allocation angle. Therefore, if it is in the common pool, and the thing allocate if the commission says all the ESCOMs or somebody had some mechanism, they should be able to get that money from the consumer. But it should be a pass-through for me. If I pay today, commission will say it is not an approved energy. Therefore, you cannot have a pass-through. Therefore, I don't have an avenue to recover it. So where do I get the money is the pension. Therefore, what I suggested, put a time frame, 1 month, 2 months, 3 months, not commission. So they can decide.
It has to be considered. Otherwise,
that's why my
time will have.
the further letter, you will ask me kindly see for a moment one para. Now, what my learned senior counsel says, you will ask me, is may not be proper.
Hear it some other day. 2:30.
But so far as interim order is concerned, you will ask me, if you will ask look at the order passed on 19/2022, the very first slogan of the respondent council, my lord, that they have not supplied, that we have not received. Therefore, this honorable court directed them to file an affidavit. Affidavit does not disclose where the power has gone then. Can I supply it to the third party? If I am supplied, then how did they discuss it, my lord, in the annual financial year?
Generated in a common pool. We don't know who has consumed that electricity.
Not lately. My lord, SLDC keeps accounts, will ask you. Older inquiry, that's what they say.
Consider.
One para ತಾವು ನೋಡಿದ್ರೆ
No time. 2:30 I got back.
Because having taken the power, they are not coming with fair this thing.
Having generated the power is entitled for the
Payment of prevailing rate, KERC says.
You are entitled for the tariff, but who has to pay the question?
That they have to say, my lord, that they have to say.
KERC has to say. You are generated
No,
power.
KERC before dishonorable court, you will ask him. KERC is a party represented by the law advocate.
Then what?
No, what could be this?
What the agreement by this time proceedings would have been concluded.
What I would like to. ಅಲ್ಲ ಇಷ್ಟೊಂದು ಮುಗಿದೋಗಿರಲ್ಲ ದುಡ್ಡು ಕೊಡುದಿಲ್ಲ ಅಂತಂದ್ರೆ again I have to knock the door of this one court. What could be decided? What I would like to say, Lord, KRC is trying to escape from the this one. There, whatever they want to say, let them say here. Instead of filing a dispute or something, my lord, in so far as the supply is concerned, let them say now before the court. Totally, or let them say what they want to say tomorrow. Let them say today.
There's no relief against you. This is 1 month I could have directed them to complete the proceeding.
So what about the payment, my lord, in the
Payment is subject to what they decide.
No, I am sorry to say this. This submission, my lord, cannot be accepted at all. Thank you, lord.
Release. Ultimately, I'll pass that order and go before the KRC answer. There's a disputed question of fact.
It only disputed facts. I have produced the document.
I have produced the document.
I have produced the document.
Yes,
they are not saying that it is not my document.
It is admitted that you have generated power, injected power into the grid in a common pool. Now the question is, who has consumed that power?
Who should say, Miller?
It is for the case after.
I am only supplier.
Adike KRC
Again, the
relegate you, give an opportunity of hearing.
Now before the court, let them say what they want to say, Miller. Just instead of trying me, all these years I have litigated before this one.
Affidavit. Counter.
What they want to say tomorrow, let them say today.
October 11th. 11th, October 11th.
Ultimately, they have to go before.
Ultimately.
Commission takes a stand. They are supposed to take a stand. How will they decide?
Let them say where the power, who has consumed the power, and let them say.
Ultimately,
instead of holding an inquiry, let them next time they say, I'll get grind to time.
Other than next week, they did now.
It's an adjudication process. I think wisely, they have not filed a statement for the honorable court. Because ultimately, the adjudicator, if he takes a stand, how can he decide? Yes, ultimately,
Tomorrow I can understand. Only one thing, my lord, subject to your lordship's final this thing, my lord. If this KRC says that the power supplied by you is incorrect, therefore we cannot pay the amount. Our prevailing rate should be given. That's what the KRC says.
3.40, but who
3.40.
is able to pay?
ಅದನ್ನ ಹೇಳಿದವರು KRC ಹೇಳ್ಬೋದಲ್ಲ ಇಲ್ಲಿ ಅಂತ. That's what I say. At least to that extent I will be relieved. Rest of the things, my lord, enhancement of the tariff, my lord, I will go.
Just find out.
I will go, my lord.
Instead of asking him to go for the KRC, just find out.
ಅದನ್ನ ಹೇಳಿದ್ರೆ ಆಯ್ತು. ಹಾಗಾಗಿ ಯಾರು ದುಡ್ಡು ಕೊಡ್ಬೇಕು ಕೊಡ್ತಾರೆ.
Then he has to notify that consumer. ಎಲ್ಲ ಮಾಡಬೇಕು.
Let them
fight. Shivaram parted ಅಂತ ರಿಲೀಸ್ ಮಾಡ್ತಾರೆ.
ಇರ್ಲಿ 11ನೇ ತಾರೀಕು ಅವತ್ತೇನು ಲೆಟರ್
ಅದು ಧಾರವಾಡ
ಒಂದಾಗಿ ಶುರುವಾಗುತ್ತೆ.
Put an end to this matter next date of hearing.
ಅಲ್ಲ ಅವರು 2 ಸಾರಿ ಟೈಮ್ ತಗೊಳ್ದು ಹೋಗಿದ್ರೆ
ಅಲ್ಲ ಫೈಲ್ ಡೀಟೇಲ್ಡ್ affidavit. Yes sir.
Senior counsel took time, otherwise I would have not required.
ಒಂದ್ ಸತಿ ನಾನು ತಗೊಂಡಿದ್ದಾರೆ, ಅವರು ತಗೊಂಡಿದ್ದಾರೆ, ಎಲ್ಲರೂ ತಗೊಂಡು ಆಯ್ತು.
I don't know.
13.
My lord, one suggestion, my lord.
Yes.
Main matter where my vendor and their vendor is locked up in litigation is posted today for reply argument of the plaintiff. The defense argument is over. And there's a direction of the Supreme Court that within 6 months the matter should be disposed of. That 6 months ends in 11th of October. Within that date, the trial court judgment will come. One way or the other. If he wins, they get it. If I win, I get it.
Right, keep it like this, same stage, and pass orders on 12th. I'll pass orders on 12th. 13th or 14th, I'll have this matter, and I'll close it. 14th. 14th. So dismiss other automatically. I think I'll hold it. Yes, I got your rules. Yes, Mr. Shivaram. Last time ನೀವು ಇರ್ಲಿಲ್ಲ ಅದಕ್ಕೆ ಇದ್ರೊಳಗೆ you cannot ಹಕ್ಕುಪತ್ರ issued ಹಕ್ಕುಪತ್ರ was issued in favor.
ಹಕ್ಕುಪತ್ರ ಇಶ್ಯೂ ಮಾಡಿದ್ದಾರೆ ವಿತೌಟ್ ಎವಿಟ್ ಮೀ ಹಕ್ಕುಪತ್ರ ಇಶ್ಯೂ ಮಾಡಿದ್ದಾರೆ ಒಂದು. ಎರಡನೇದು there is a suit my lord which has been filed. Suit came to be regular appeal came to be allowed filed by the cooperative society. Matter has been remanded. That has been challenged by the very same person my lord for the in RSA.
But they could not have cancelled the Hakkupatra.
Without evicting me, my lord, without, that is one thing, your lordship. Secondly, what has happened, your lordship, may kindly see for a moment, your lordship. The person who has been allotted a site, my lord, under the RCS scheme, he is not entitled for allotment itself, one thing. Secondly, my lord, second, he is a landlord. Yes.
Not entitled, there is a procedure prescribed for cancellation of the Hakkupatra. Let them adopt the procedure and cancel it.
No, but the executive officer proceeded to pass an order, not on that basis. Since there is a suit, order has been passed in the suit, dismissing the suit filed by the Milk Producers Society. I am allowing the petition, that's what the order says.
And reserve liberty to the Gram Panchayat to pass appropriate order in accordance after notifying the petitioner. ಹಕ್ಕುಪತ್ರ ಕೊಟ್ಟ ಮೇಲೆ ಕ್ಯಾನ್ಸಲ್ ಮಾಡ್ಬೇಕಂದ್ರೆ ಇಶ್ಯೂ ನೋಟಿಸ್.
ಹಕ್ಕುಪತ್ರ ಸೈಟ್ ಇಲ್ಲ ಅಲ್ಲಿ ಸೈಟ್ ಅನ್ನ ಇವರು ಕೊಟ್ಟಾದ್ಮೇಲೆ ಈಗ ಆಲ್ರೆಡಿ ಫಂಕ್ಷನ್ ಮಾಡ್ತಾ ಇದಾರೆ ಅವರು.
ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿ ಮ್ಯಾನ್ ನೋಡ್ತಿಲ್ಲ ಅಷ್ಟೇ ಹೇಳ್ತಾರದ. ಐ ಆಮ್ ನಾಟ್ ಸೇಯಿಂಗ್ ಎನಿಥಿಂಗ್.
It was only a technical this thing, my lord. Cancelling a allotment of ಹಕ್ಕುಪತ್ರ is only a technical
ಅಲ್ಲ. Tomorrow somebody executes the sale date and if they cancel without issuing notice, your rights are affected. Rightly or wrongly, Hakkupatra may have been granted, but there is a procedure to stay.
How it was granted, you will see. One of his brother was a Mandal Panchayat Pradhan at that time.
He is not entitled, let them cancel it.
That's correct, you will see. But if a man, my lord, who is a landlord, who is not a resident of the village, is he entitled for the allotment of a site, my lord, under the RCS scheme?
Legally granted.
Yes.
The procedure prescribed. Let them adopt the procedure and till then, let them take appropriate action in accordance with law.
Society is functioning, your lord. If there are about
800, but that is not a ground for cancelling to allot the land in favor of the milk cooperative without cancelling the Hakkupatra. He may be in an illegal position.
No, it is not. I am not.
He cannot be evicted. I am not going into the question of eviction. Only the cancellation of the Hakkupatra to that extent. Not more than
Not my same, lord.
Not going to the question of possession. Possession, it is parties are at liberty to agitate before the civil court.
Even the said allotments, my lord, I wanted to produce those documents. That's all forged one, my lord. That is not signed by the authority itself. That is how they managed the allotment letter, your lordship, Hakkupatra.
Indian writ petition.
Petition ಅಲ್ಲಿ executive officer order ನ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರು. EO order has been challenged.
ಏನಂತ? And the No, the first petition filed by Mr. Sadashivaya.
Kata, unless the inquiry is held, my lord, and the order is passed by the authority, my lord, cancelling the allotment, no Kata can be made in their favor because right or wrongly we are.
Kata itto. Kata was standing. They resolved without issuing notice. Accordingly, above the following, WP number 45866 of 2017 is allowed. The impugned order dated.
Formally allowed, my lord. Reading application filed when
Not necessary.
formally it may be allowed, my lord.
That is in serial number 45866 of 2017, madam. Order sheet heard on IA1 of 2022. For the reasons assigned in the application, IA1 of 2022 is allowed. The applicant in IA1 of 2022 is permitted to come on record as respondent number 4. Petitioner counsel to amend the cost title to amend the cost title. Is allowed. The WP number 45866 of 2017 is allowed. The impugned order dated 23/3/2007 passed by the second respondent at Annexure G, and the endorsement dated 28/10/2016 issued by second respondent at Annexure L are hereby quashed. The respondent number 2 is hereby directed to restore the name of the petitioner in the property tax register maintained by the second respondent forthwith. However, liberty is reserved to the respondent number 2. Sadashiva, our respondent number 2 is granted liberty to petitioner, the respondent number 2, Gram Panchayat, is permitted to take appropriate action in accordance with the Akkupatra. The respondent number 2 and the respondent number 4 are granted liberty to challenge the Akkupatra granted in favor of the petitioner in accordance with law. All conditions are kept open. All within in accordance with law, everything is cost title amendment madi. Fourth respondent IA is allowed. A milk union cooperative society no fourth respondent the party madi. Amend the cost title. Writ petition in view of the order passed in WP number 45866 of 2017. The writ petition number 51706 of 2019 stand disposed of. ಅದೇ ಹೇಳಿದ್ರು fourth restore ಖಾತಾ. ಅಯ್ಯೋ ಬೇಡ, ನಾನು ಅಮೌಂಟ್ ಧಾರವಾಡ ಇಲ್ಲ ಬೇಡ ಬೇಡ. ಯಾವುದು ಬರ್ತಾರೆ somebody else will hear. Ram, ತುಂಬಾ ಪಾಠಡ್ ಆಗ್ತದೆ. Not carried. Same roster if I continue then. ಆಯ್ತು ನೋಡೋಣ. I'll see in the chamber. If I fail it, I'll see it. ನೋಡ್ತೀನಿ. I treated your other matter as a parted. We'll do something about it. ನೋಡೋಣ. Yes. I'm not going to that aspect. ಏನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ, ಮಾಡಿರ್ಬೋದು. I'm only going on the question of Kata. Whether possession, I'm not going. The question as to whether the petitioner or the respondent number 4 is in possession of the subject property cannot be gone into in this writ petition. All contentions are kept open. Right, Sir?
Yes.
Paragraph. The accused number as a password. 30th, I'll keep it, then thereafter I'll reserve and pass orders. 30th. Ask Manmohan to come on that day, some clarification is required. 30th.
Number 43.
1.5 years.
Yes, madam. Delay. 12 years. Learned counsel for the petitioner submitted the application under section 5 of the PTSL Act was filed after an inordinate delay of more than 12 years. So, learned HCGB for respond 1 and 2, issue major notice response 3 and 4. The operation of the order dated 18/6/2010 passed the second respondent at Annexure B is hereby state. Just after service of notice. You appeal for whom? What is the matter about?
This is a petition filed seeking quashing of a letter dated 22/10/2020, wherein the assistant executive engineer grants permission to one Mrs. Saroja to construct a milk parlor. Plus, my issue is this, my only grievance is the construction is right in front of my house. It's right in front of my house. My only grievance is that I will just show 3 documents in the petition to show how they've been aiding and abetting the respondents, been aiding and abetting the respond number 7.
Now it is already constructed. Milk parlor is constructed.
It's already constructed, but I will just show 3 documents as to how they've legally done this process.
Yes.
First, annexure A, page 17.
Yes.
This is the letter granting permission, Madam. But at page 18, they have stipulated about 7 or 8 conditions, and I am agreed by the 7th condition, Madam. It's at 18. ನಂದಿನಿ ಹಾಲು ಮಲ್ಲಿಗೆ ಸ್ಥಾಪಿಸುವ ಬಗ್ಗೆ ಅಕ್ಕಪಕ್ಕದ ಖಾಸಗಿ ಜಮೀನು ಮಾಲೀಕರಾದ ಅಥವಾ ಇತರ ಸ್ಥಳೀಯ ವ್ಯಕ್ತಿಗಳಿಂದ ಅಪೇಕ್ಷಣೆ ಬಂದಲ್ಲಿ ಈ ಇಲಾಖೆ ಜವಾಬ್ದಾರಿ ಇರುವುದಿಲ್ಲ. But this is the first condition. They issue permission, but they also say we are not responsible.
This is a permission is granted in your favor.
It's granted in favor of respondent number 7. One is,
You are not aggrieved.
my house is right in front of
Right.
the illegal farm.
This condition is in your favor.
It's my favor, no. They say we are not responsible if anybody comes and objects.
Yes. In case if you object, you are not responsible.
So
That's
this is one of the conditions. The second document, my lord, they say, they themselves say that this is an illegal construction at page number 27. This is issued by the panchayat development officer. He says this is an illegal construction and you have to take steps to demolish.
26. Page 26.
Second,
Paravan padiyade. Without building list.
illegal construction. ಆದ ಕಾರಣ ಗ್ರಾಮ ಪಂಚಾಯತ್ ಅನುಮತಿ ಪಡೆಯುವುದು ಕೂಡಲೇ ಕಟ್ಟಡ ರಚಿಸುವುದನ್ನು ತಕ್ಷಣ ನಿಲ್ಲಿಸಿತು.
What has happened after this notice was issued? Have they taken any?
ಏನು ಮಾಡಿಲ್ಲ.
Now you are aggrieved by?
I'm aggrieved by annexure A and K.
What is K?
That's K is another letter that they have issued, seeking for electricity supply. Even after they say that this is illegal, they issue another notice saying they need electricity supply, and that is also granted.
Then it comes for the petitioner. The respond number 3 submits that who has issued that notice, notice for removing that illegal construction. R2. R4. No, annexure G is R2. So notice is issued by the second respondent calling upon which respondent? Seventh respondent to stop construction on the subject property. The second respondent has not taken any action to remove the illegal construction put up by the seventh respondent. Full stop. Learned AGA for respondent number 1 issue emergency notice. Respondent number 1 4 1 and 4. 3 and 4. 3 and 4. 3 and 4. Issue emergency notice to respond 2, 5, 6 and 7. 7. Which already is milk parlor is functioning. Full stop. Respondent. Meanwhile, respond number 2, 2, 3, 4. To take appropriate action against the seventh respondent for having put up illegal construction on the subject property in accordance with the government land. But construction.
One more point with the district campus. A division bench of this high court says 40 meters of either national or
The building line. Now that it's a matter of a final order. Consider at the time of final disposal. Now it is already put up. You not stop madakagala. Should have come at the earliest point of time. Because earliest point of time we could have stalled it. Now that the milk parlor is functioning, at this point it cannot be stayed. This immediately after service of notice. To take action. Issue emergency notice. This immediately after service of notice. Remove this code. This madam, this is matter on October 20th. 20th, October 20th. For consideration of interim care. Yes. Yeah, purchaser or renter? How many years delay?
Was heard for some time.
Yes.
So the property claimed by the GP owner of the original rent is totally different from the property purchased by me. Spite of it, my side it is cancelled. Therefore, to find out
Yes, madam. Fifty-five bar.
My property is different, their property is different. One is, in spite of it, my sale deed is cancelled.
So property can be identified. Your property. Yes, madam. Yes, madam. Any objection?
Identification under 55/3, 90 and the wrongful it is entered. I have purchased 90, the original number is 42. 42 is quoted thereafter 90 number is given. What is claiming is 55/3 is also numbered as 90. Therefore, properties are totally different. And on the ground that 55/3 is quoted as 90, the sale deed of the petitioner is cancelled. Can you see the synopsis itself as very clear?
The respond number 5, Mr. Kumbar. Respondent number 5, claiming that the property what was granted to you?
55/3.
Claiming that proper land bearing survey number 55/3 measuring
2 acre 10 guntas.
2 acres 10 guntas situated at Emmanhalli village, Mannali Taluk, was granted in favor of one Hanamappa alias Hanumantappa on 21/11/1956. Upside price. Upside adu barla. First upside price of rupees 237.595 subject to certain terms and conditions. Full stop. ಇದೇನು ಸೇಲೆ ಮಾಡಿಲ್ವಾ ನೀವು?
ಮಾಡೇ ಇಲ್ಲ, ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿಲ್ಲ. But this case is my father has never.
Petitioner claims to be the owner of so answers. Yes, madam.
Apparently, this is not my code is 42/3 and 2. Is 43/1 is granted. Second, third column. 42/2. Next one is 42/3. Next one is 42/2.
Code really. Madam, what is purchased by the petitioner is 42/2 and what is granted is 42/1. He has purchased 42/2.
2 and 3.
2 and 3.
2 and 3, 1 acre 20 guntas is totally 3 acres.
And what is granted is 42/1. 42/1. 1.20 acres.
3. Altogether,
Yes, yes, yes. Madam, petitioner claims that land bearing survey number 55/3 measuring 2 acres 10 guntas and 42/1 measuring 1 acre 20 guntas, both situated at Emmanhalli village, Mannali Taluk, was granted in favor of
Hanumappa alias Hanumantappa.
Hanumappa alias Hanumantappa with a grant order dated 14/11/1956. Stop. Petitioner claims that petitioner filed an application under section 5 of the PTCL Act alleging that the said lands were conveyed in favor of the petitioner in contravention of section 4(1) or 4(2). When was the alienation made?
Alienation was made.
Sold, were conveyed in contravention of section 4(1) of the Act. Stop. Allow it, the Assistant Commissioner allowed the application after allowed the application and restored and resumed and restored the subject land in favor of the fourth respondent, fifth respondent, against which the petitioner filed an appeal under section 5 of the Act before the Deputy Commissioner. The Deputy Commissioner concerned dismissed the appeal, confirming the order passed by the Assistant Commissioner, restoring the subject lands in favor of the petitioner, in favor of the fifth respondent, against which the present petition is filed. Learned counsel appearing for the petitioner submits that the land which was granted, submits that the petitioner is the purchaser of land bearing survey number 42/1, measuring 1 acre 20 guntas and 42 and survey number
42/2 and 42/3.
Learned counsel for the petitioner submits that the petitioner is the purchaser of the land bearing survey numbers 42/1 and 42/2 and 42/3, both measuring 1 acre 20 guntas each.
Corresponding number 90 and 91.
Corresponding survey numbers 90 and 91 to a registered sale deed executed by Gauramma.
1988.
To a registered sale deed dated 13/4/1998, executed by Gauramma
And Hanmantappa.
Hanmantappa. Yaar Hanmantappa ivaralla and Hanmantappa. Hence he submits that the land purchased by the petitioner. Hence he submits that the petitioner has not purchased the granted land in favor of Hanmantappa, and as such the proceedings, as such the PTC, the provisions of PTCL Act are not applicable. On the other hand, learned counsel appearing for respondent number 5 submits that the subject lands are granted lands as defined under section 3(1)B of the PTCL Act, and the Assistant Commissioner has rightly restored the subject land in favor of the respondent number 5.
Therefore, application could not have been made.
Since there was a dispute with regard to the identity of the subject land, an application under section 5 of the Act was filed.
So therefore, based on that,
Submits that the petitioner under misconception that the subject lands were conveyed in contravention of section 4(1) of the Act, filed an application under section 5 of the PTCL Act, though the granted lands were not conveyed in favor of any person. Hence, he submits that necessary direction to be issued to the Tahsildar concerned for mutating the name of the fifth respondent in terms of the grant order dated 21/11/1956 at Annexure C. One day grant land. In terms of the grant order dated 21/11/1956 and 3/9/1957 at Annexure C. One day examine the sufficiency to the learned counsel for the parties. The petitioner is the purchaser of land bearing survey number 42/3 and 42/3. The respondent number 5 filed an application under section 5 of the Act for restoration of land bearing survey number 55/3 and 42/1 under the misconception that the said lands have been assigned with new survey number 90 and 91, 90 and 91. However, the respondent number 5 has categorically admitted that the subject land were not conveyed in favor of any person, and having admitted the same, the application filed under section 5 of the PTCL Act was not maintainable. Accordingly, apart the following, which is allowed, the impugned order dated 22/9/2014 passed by the second respondent at annexure A, and the order dated 8/10/2012 passed by respondent number 3 at annexure B are hereby quashed. The fifth respondent is granted liberty to submit an application with the fourth respondent for mutating his name in the revenue records in terms of the grant order dated 21/11/1956 and 3/9/1957. If such an application is submitted, because the third respondent, the fourth respondent, to mutate the name of the fifth respondent in accordance with law.
Passing this, they have given possession of my property to the why not say?
It is needless to state that the petitioner is entitled for restoration of the lands which have been resumed and restored in favor of the fifth respondent. If resumed and restored in favor of the fifth respondent. Pending item, Dr. In amendment to the ಎಷ್ಟು ವರ್ಷ ಡಿಲೇ on Madam, even otherwise the application, the fifth respondent is not entitled for restoration of the subject land if the application under section 5 of the Act was filed after an inordinate delay of more than 27 observation.
Yes, I am representing petitioner in this matter, and the matter is fictitious. Fictitious, yeah, and it may be dismissed.
Both the matter, sir. Third matter is Varun Papi Reddy.
Yes, I am proxy counsel.
And who is Mr. Kumar? What's your name? 51. 51. See, so and so Land Council appearing for the petitioner submits that seeks leave of this court to withdraw the writ petition. Submission is placed on record. Petition is accordingly dismissed as withdrawn. Madam, serial number 51. Is it, madam, what is 51.1? Yes. Delimitation. Then 5 years, more than 6-7 years. In fact, just
2 elections has been held.
2 elections like it in. Delimitation. No, this does not survive for consideration. Already elections have been conducted. Delimitation matte ಮಾಡ್ತಾ ಇದ್ದಾರೆ. In view of that, it becomes infectious. 12 weeks time has been extended. Then this becomes infectious. ಅಲ್ಲ ನಾವು ಫ್ರೆಶ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಇವಾಗ 12 weeks. The government has taken a decision for delimitation of wards for conducting constituency. Gram Panchayat ಇಲ್ಲ. Gram Panchayat. ಏನು 2 election ಆಗಿದೆ ಅಲ್ಲ, ಇನ್ನೇನು ಮಾಡಕ್ಕಾಗಲ್ಲ. Nothing can be done.
regarding population wise, Milad, it was reconstituted by the management. He has recommended the government. Government has reconstituted.
The delimitation of what? Again, 2 elections have been conducted thereafter.
The coming election, it may be.
Parallel.
Representation may be considered.
Yes, you know, good, really.
What population ಆಗಿದೆ ಅಂತ ಅವರೇ ಕಮಿಟಿ ಅವರೇ ರೆಕಮೆಂಡ್ ಮಾಡಿ.
ಈಗ ಚೇಂಜ್ ಆಗಿರುತ್ತಲ್ಲ 7 years ಆಯ್ತು ಅದು.
ಜಾಸ್ತಿ ಆಗಿದೆ population ಆಗ್ಲೇಬೇಕು. More than 8,000, 9,000 ಇದೆ. ಅದಕ್ಕೇನೆ ನಮ್ಗೆ ಹೊಸದೊಂದು ಮಾಡಿದ್ರು. ಅದ್ರ ಪ್ರಕಾರ ಮಾಡಲಿಲ್ಲ ಟೀಚರ್ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದ್ರು 10 to 12 kilometers.
Liberty can be given to submit representation. Madam, could you? What is the challenge? Sure, it costing the order passed by the annexed. What is annexed D?
It is passed by the regional commissioner. Page 21 meter. 5 ರಿಂದ 12 kilometers ದೂರದಲ್ಲಿದೆ ಅಂತ wrongly has taken the decision. All villages from 56 kilometers. Next annexation will happen. Sector E and F. The report submitted by the engineering section. ಉಪವಿಭಾಗ ಸಹಾಯಕ ಕಾರ್ಯಪಾಲಕ ಇಂಜಿನಿಯರ್ ಕಚೇರಿ.
This petition is filed challenging the notification issued in Gram Panchayat.
Komlapura Gram Panchayat, new Gram Panchayat established by the government. National Hotel Tagdu, MN Komlapura Gram and Panchayat.
It should, whereby
more population
thereby Somlapura new Gram Panchayat was constituted for conducting election to the members of Gram Panchayat, which was held on the year 2015. In view of effect of time, the impugned notification as suspend force, and as such, the relief sought for in this petition cannot be granted. Accordingly, petition stand disposed of, granting liberty to the petitioner to submit representation with the second respondent for delimitation of wards. Gather the section. Madhyan end 2:30. 2:30. Yes, madam. This is after the 8th. Yes, 18th. Inform on that.
I will inform the other side.
Yes, sir. All matters will be taken up. Yes, madam. Yes, madam. It will be adjourned after vacation. Yes. Yes, sir. Wherever intermodals are operating, it pays. No. I'll see. I it will be discussed in Somashekar Ramanagat way. Delay it, doesn't make it. I after 11th. Right. 11th. I was covered. It will be discussed any day. If not today, tomorrow. 11th. Our bed answer late. I, Mr. Somashekar, it will be discussed anyway, 33 years delay. I,
Court officer? Court officer? Court officer? Sir, ಕೇಳಿಸ್ತಾ ಇದೆಯಾ? Court officer? Sir, ಕೇಳಿಸ್ತಿದ್ಯಾ? Court officer?
Yes, sir. Ready. Yes, sir. Tomorrow. And after. Serial number? 130. 13 after vacation. For after vacation. Hello? Serial number 3 after vacation. ಮಾಡಿ ಮತ್ತೆ OS ಪೆಂಡಿಂಗ್ ಇರ್ಬೋದು, ಇಂಜೆಕ್ಷನ್ ಆರ್ಡರ್ ಇದ್ರೆ ಮಾಡಿ ಅದನ್ನ. 10th. Before vacation, Nagala. Before vacation, not possible. 10th, I'll have it on 10th. ಅದೇ ಏನ್ ಮಾಡೋದು? Which is it? The section provision. Section 4. Another petitioner has sought for challenge the notification establishing new. Is challenge the constitution of new panchayat. Annexure C. ಅದು ನಿಮ್ದು ಇದು ಅಪೀಲ್. Annexure C ನೋಡಿ that is challenged. Annexure D. Yeah, from by virtue of impugn notification, the constituency, the newly constituted Somlapura constituency was merged with Chelur. ಅದೇ ಹೇಳ್ತಾರಲ್ಲ ಅದೇ ಅಷ್ಟೇ ಕರೆಕ್ಟ್. MN Kote and merged with the MN Kote Gram Panchayat. Subsequently, election to the MN Kote Gram Panchayat was conducted, and the term of the members of the Gram Panchayat has expired during the pendency of this writ petition. In view of the same, the impugn notification having spent forth the relief sought for in this writ petition cannot be granted. Accordingly, petition stand disposed of, granting liberty to the petitioner to submit an application for to the second respondent to constitute the new Gram Panchayat in accordance with section 4 of the Karnataka Gram Swaraj and Panchayat Raj Act 1963. ಆಯ್ತು ಅಲ್ಲೇ ಎಲ್ಲಿ ಬರ್ತಾರ ಜನ ಟೇಕ್ ಲಿಸ್ಟ್. Oh yes,
Lord, passed over, madam. My matter was passed over in the morning, Lord. Serial number 12.
12, Mr. Ballard, it will be taken up. ಏನದು
ಏನಿಲ್ಲ, ಅದ್ರಲ್ಲಿ ನೋಟಿಸ್ ಇಶ್ಯೂ ಆಗ್ಬೇಕು ಸ್ವಾಮಿ. ಇಟ್ಸ್ ರಿಗಾರ್ಡಿಂಗ್ respondent number 1 and 2. I mean, all the respondents, notice has to be issued because her appointment is in violation of the guidelines issued by the state government.
Madam, bill number 12, list number 1.
Lord, respondent number 4, who is just qualified as a SLC pass, my lord.
Issue emergency notice to respond 1 to 4. Just after service of notice.
Obliged.
Yes, madam. Yes, ma'am. Can it be considered, madam? In accordance with law. Where is the representation, madam? A to A4. Yes, in representation, you know. Construction in violation of the sanctioned building. Violation of the sanctioned building. Right, violate. The petitioners submitted representation with the respondent BBMP. The respondent BBMP to take action against the respondent number 7 and 8 for putting up in violation of the sanctioned building plan. Petitioner's grievance is that the said representation have not been considered. Donut Council appearing for respondent BBMP supports that the representation submitted by the petitioner will be considered in accordance with the reasonable timing mandate. Therefore, it is expedient to dispose of the petition, directing the respondent number 13 to 7 to consider the representation stated.
One legal notice as well.
1st October 2021 and notice dated 16/3/2022 submitted by the petitioner at Annexure A and Annexures A and C and pass appropriate order in accordance with law within a period of 6 weeks from the date of physical service.
Say what they have done.
Then I have to issue notice. Then I'll issue notice to the private sector.
The reason also.
Issue emergency notice to respond 7 and 8. This is matter immediately after service of notice. Meanwhile, respondent, the officer concerned of the respondent BBMP to visit the subject property and conduct an inspection as to whether the construction put up by the respondent number 7 and 8 is in accordance with the sanction plan or not, and submit the report on or before the next date of hearing. Would have taken time. $230. Mandamus. Hello, is it Madilla? Assignment. Yeah, madam. File. Carry that BBMP. Serve a copy on Banu Prakash. Either Battegoda. Madam, office to reflect the name of NR Jagdishwar as counsel appearing for respond 1 to 3. This is matter on 30th. It's after vacation. Yes. It is in the nature of public interest. Allah, you are seeking for removing all the slabs in Rajkalvi all over Bangalore. Anyway, it is being monitored by the division bench. Removal of encroachment over storm water drains. The Rajkalvi, it is subject matter of for the division bench. But you file appropriate application, I cannot do it. Before the registry. Just after vacation. Right after vacation. 6 years. Well, other side.
Lord, serial number 4, I represent the petition.
4 is adjourned. 4 is adjourned.
Lord, they are taking adjournment, Lord, repeatedly, Lord. They are supposed to submit a report. They have undertaken
Number 4 in this
a.
case, my lord.
Allah, you did not appear, so it was adjourned. 4. Serial number 4 was called out after vacation.
Please, please.
On 15/9/2022, there was no representation on behalf of the petitioner. Today, when the matter is called out, there is no representation and petition is dismissed for want of prosecution.
Serial number 8, I am representing petitioner, my lord.
Yes.
My lord is a writ of mandamus, my lord, seeking transfer of Kata, my lord.
Consider. Adabodha.
There is already there is a Kata in favor of for the entire property.
Entire property. Mr. Muniraj.
My lord, as per
you considered your representation and endorsement. Could you challenge this endorsement? Yavag madidda endorsement.
1/2020 is received by them personally.
Challenge it.
I am not aware about, my lord. I will challenge the endorsement, my lord. Kindly liberty may be issued.
Yes, sir. Petitioner submit an application to enter his name in the mutation register. Mutation register. Property tax register.
Kata, my lord.
Register.
Kata.
Maintained by the respondent Gram Panchayat in respect of property bearing Adam Liren. Another 2 copies. Property assessment, Kaneshwari number 2112/1806, measuring east to west, 36.5 square feet, north to south, 118 square feet. Full stop. As per the family partition deed. Full stop. During the pendency of this, the respondent Panchayat has considered the application submitted by the petitioner and rejected the same. Hence, the rule sought for in this petition does not survive for consideration. However, according to petition stand before the giving liberty to the petitioner to challenge the endorsement dated 12/1/2021 issued by respondent number 2 in accordance with.
My lord, the copy of the endorsement may be directed to the respondent to issue.
Copy code. Copy code. So, Gram Panchayat municipal form.
Grateful, my lord.
My lord, it is serial number 9, my lord.
Yes.
For the petitioners, my lord.
Paying for time just after vacation.
Please, my lord. Right.
Who appears for other side? What is the representation of the petitioner subject? Carrying on commercial activity in a residential zone. Petitioner submitted a representation corresponding BBNP to take action against second respondent for carrying on commercial activities in a residential zone. Residential zone. Other. Approach action against respondent number 2 for carrying on commercial activities in a residential building. Petitioner's grievance is that the such representation has not been considered. Stop. The running of a commercial establishment in a residential is against the zonal regulations of revised master plan 2015. Hence, the full stop. Therefore, it is expedient to dispose of the petition, directing the respondent number 1 to consider the representations dated 4/11/2015, 18/5/2017, and February 2021 submitted by the petitioner at annexures E, F, and G, and pass appropriate order in accordance with law within a period of 8 weeks from the date of receipt of the certificate. After revision.
I appear for respondent. Where in the writ petition may kindly be looked into?
Yes.
Where in the writ petition may kindly be looked into?
Stop inquiry referred. Huge delay and referred. ಅದೆಲ್ಲ ಬರಲ್ಲ. CBI ಎಲ್ಲ ಕೊಡಕ್ಕೆ
ನಮಗೆ ಆಪರೇಷನ್ ಆದ್ಮೇಲೆ ಓಕೆ ಅಂಡ್ ಆಯಿಂಟ್ಮೆಂಟ್ ಟ್ಯಾಬ್ಲೆಟ್ಸ್ ಏನಿರಲ್ಲ ಒಳ್ಳೆ
ಇದಾಯ್ತು 21 90 ಡೇಸ್ ಆಗಿದೆ.
ಎಷ್ಟು ಪೀಸ್ ಇದೆ ಟೋಟಲ್? ಒಂದು 10 ಪೀಸ್ ಕನೆಕ್ಟೆಡ್ ಎಷ್ಟು ಕೊಡ್ತಾ ಇದ್ದೀರಾ?
ಡಿಸ್ಟರ್ಬೆನ್ಸ್ ಜಾಸ್ತಿ ಇದೆ. ಇದು ಸೆಂಟ್ರಲ್ ಗವರ್ಮೆಂಟ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಪ್ರಕಾರ ಕಾನ್ಸ್ಟಿಟ್ಯೂಟ್ ಆದ ಬಾಡಿ ಅಂಬಸ್ಮನ್ ಅವ್ರ ಮುಂದೆ ಪೆಂಡಿಂಗ್ ಇದೆ.
ಅಡಲ್ಟ್ ಎಷ್ಟು? ಬೇಡ ಇನ್ನು ಆ ಲೆವೆಲ್ ಹೋಗಿಲ್ಲ. ಬಾಡಿ ಸ್ವಲ್ಪ ಕ್ಲೀನ್ ಮಾಡಕ್ಕೆ ಇನ್ನೂ ಆಗಿಲ್ಲ ಸ್ಟಾರ್ಟ್ ಆಯ್ತು ಅಂತ ಕೊಟ್ಟಿರಿ.
ಡಿಸ್ಟರ್ಬೆನ್ಸ್ ಜಾಸ್ತಿ ಇದೆ ಸ್ವಾಮಿ. ಯಾರೋ ಮಧ್ಯೆ
150-250 rupees. ಇದು ಹಿಮಾಲಯ 100 ಪೀಸ್ ಇದೆ. 100 rupees 70 rupees. 80 rupees.
ಯಾವ್ದು
ಮೇಲೆ ಜಾನ್ಸನ್ ಅಂದ್ರೆ 250 rupees. 372
Petitioner's complaint has been registered. What was the complaint lodged by you? The petitioner submitted a complaint with the
ಅದು ಈಗ ಒಂಬತ್ತು ಮುಂದೆ ಪೆಂಡಿಂಗ್ ಇದೆ ಎಂಕ್ವೈರಿ. ಅವ್ರು ಏನ್ ಹೇಳ್ತಾರೆ ಅಂದ್ರೆ
With the
9
second respondent
ಪೆಂಡಿಂಗ್
to
ಸ್ಟಾಪ್
conduct-
ಮಾಡ್ಬಿಟ್ಟು CBI ಕೊಡಿ.
I thought to conduct an solve the complaint with the second respondent to conduct an inquiry. To conduct an inquiry to inquire into the allegation of misappropriation of fund under the Manrega scheme. The second respondent in turn by communication dated 3/7/2021. What did he do?
He referred it to ombudsman.
Referred the complaint to the respondent number
3.
2, ombudsman.
3. Respondent number 3.
Ombudsman for conducting an inquiry, to conduct an inquiry and submit a report. Petitioner's grievance was that the respondent number 3, ombudsman, has not taken any action, has not conducted an inquiry and submitted the report.
ಮೇ ಸಬ್ಮಿಟ್. ಇವರು ಬರ್ತಾನೆ ಇಲ್ಲ, ಅವ್ರಿಗೆ ಅಲ್ಲಿ ಎನ್ಕ್ವೈರಿ ಬೇಡ ಅಂತ CBI ಎನ್ಕ್ವೈರಿ ಬೇಕಂತೆ. ಇವ್ರು ಬಾರದಿದ್ರೆ ಅವ್ರಿಗೆ ನೋಟಿಸ್ ಕೊಡ್ತಾ ಇದ್ದಾರೆ. ಸೆಕ್ಷನ್ ಅಲ್ಲ ಅದು, ಇಲ್ಲ ಸ್ವಾಮಿ ಅದಲ್ಲ. 196
ಸೌಮ್ಯಾಜಿ ಒಂದು ನಿಮಿಷ ಇರಿ, ಅದು 296B.
ಅದು 296B ಅಲ್ಲ ಸ್ವಾಮಿ, ಅದು ಗೈಡ್ಲೈನ್ಸ್ ಕೆಳಗೆ ಕಾನ್ಸ್ಟಿಟ್ಯೂಟ್ ಆದ ಒಂಬಸ್ಮನ್ ಸೆಂಟ್ರಲ್ ಗವರ್ಮೆಂಟ್ ಇಶ್ಯೂ ಮಾಡಿದ ಗೈಡ್ಲೈನ್ಸ್.
ಏನದು ಗೈಡ್ಲೈನ್ಸ್? ಬುಕ್ ಕೊಡಿ, ಆ ಬುಕ್ ಕೊಡಿ.
24/5/2013.
I'll look into that guidelines. Yes, Mr. Samuel.
Very good.
Section
clause.
30.7.
Section under section 27(1) of the National Rural Employment Guarantee Act provides for establishment of the office of ombudsman for redressal of grievance in a time-bound manner. So, in pursuance of the same,
Central government instructions.
Since of the same, the central government has issued certain guidelines for redressal of grievances and disposal of complaints relating to implementation of NREG Act and the schemes made under the Act by the states. So, clause 13.7 of the said guidelines specifies that all cases not involving complicated question of fact or law shall be disposed of within 15 days. Other cases may be disposed of within 45 days. The respondent number 3 has not acted upon the communication issued by the.
You may submit. Notice ಕೊಟ್ಟರು, ಅವ್ರು ಬರ್ತಾ ಇಲ್ಲ, ಅದಕ್ಕೆ ಡಿಸ್ಪೋಸ್ ಮಾಡಕ್ ಆಗ್ಲಿಲ್ಲ.
ಆಯ್ತು,
ಈಗ ಬಂದ್ರೆ ಡಿಸ್ಪೋಸ್ ಮಾಡಬಹುದು.
Is under an obligation to dispose of the complaint within 15 days as prescribed under clause 13.7 of the said guidelines. Therefore, it is expedient to dispose of the restriction, directing the
third
respondent to dispose of the complaint filed by the petitioner in terms of the communication dated 3/7/2021 issued by second respondent at annexure H within a period of 30 days from the date of receipt of the certificate copy of this order. ಕೊಟ್ಬಿಡಿ ಮೇಡಮ್.
It may be observed, my lord. Petition may be, ಯಾಕಂದ್ರೆ ಅವ್ರು ಬರಲೇ ಇಲ್ಲ, ನೋಟಿಸ್ ಕೊಟ್ಟಾಗ ಬರಲೇ ಇಲ್ಲ. It may be observed. Let him cooperate with.
it is made clear that the petitioner shall cooperate in disposing of the complaint by this respond number 3. Yes.
Small matters, I'm not for the annexure AP in the like.
Our objection is time ಕೊಡ್ಬೇಕಲ್ಲ. Yes. Then it has to be heard. Setbacks in the building bylaws ಪ್ರಕಾರ ಏನ್ ಮಾಡ್ತಾರೆ ಅದು ಮಾಡ್ತಾರೆ. That is plan submitted. What is the plan? Under the town and country plan. Yes. Now they are imposing the setbacks as per the building bylaws. Color, they have to be. I went on 30th will discuss it. 30th. Who pays for third response? Yes. Soraba. After completion of the meeting, the offer the respondent to petitioner after obtaining sanctioned building plan and license constructed a commercial building on the scheduled property. Petitioner, after completion of the construction, the petitioner submitted a representation with the third respondent to issue no objection certificate and occupancy certificate. No objection certificate is again. To issue completion certificate. Stop. The third respondent issued a notice to the petitioner, calling upon the petitioner to remove 1 feet into 131 feet towards eastern side and 1 feet into 134.6 towards western side of the building, which was constructed in violation of the sanctioned building plan. Other than sanction, it was the petitioner thereafter removed the illegal construction and submitted a representation afresh with the respondent number 3 to issue completion certificate, occupancy certificate. Petitioner's grievance is that the said representation have not been considered. Respondent number 3, 4 and 5. Okay. Sorry, 3. First, CC1, respondent number 3. Respondent number 3, those served with notice have remained absent. Therefore, it is explained to depose the petition, directing the respondent number 3 to consider the representation dated ಎಲ್ಲಿದೆ annexure? And consider the representation dated 23/6/2022 submitted by the petitioner at annexure and pass appropriate order in accordance with the, in a period of 4 weeks from the date of receipt of the certificate of the order. Yes, Mr. Bandari, whether it can be considered on. ಏನಂತ petitioner apprehending that the respondent is likely to form a road, to form a road on the property belonging to him without following due process of law, has filed this writ petition. Learned counsel appearing for the respondent, number 1 and 2. ಏನ್ ನಿಮ್ದೇನು ಮಿಸ್ಟರ್ ಹರೀಶ್ ಭಂಡಾರಿ? ಅದೇ learned counsel submits that the present writ petition is not maintainable on the mere apprehension that the respondents are likely to form the road without following due process of law. In view of the same, petition stand disposed of. However, it is made clear the respondent 1 and 2 shall not form road on the subject property belonging to the petitioner without following due process of law.
Right up beyond the road, the default concept now is start. Because there is also stand.
Yes, madam, you have your phone. You have your phone. Arun. Yes, what has happened now?
How this is profit, and as on today, you got 7 days working.
Now they have stopped construction. We'll have it after vacation. Just after vacation. You are claiming Kata on the basis of sale deed. ತಗೊಂಡಿದಾರಂತ. You consider the petitioner having purchased the site bearing number 476 situated at second stage west of Port Road, Mahalakshmipuram, Bengaluru, to auction sale deed dated 28/5/1999, submitted an application with the respondent BBMP for entering the name of the petitioner in the property tax register as specified under section 149(3) or 114(3) another, but 149(3) of the BBMP Act 2020. Petitioner's grievance is that this representation has not been considered. Section 149(3) of the BBMP Act 2020 specifies that on specifies that whenever such transfer comes to the knowledge of the chief commissioner or authorized officer through such notice, the name of the transferee shall be entered in the property tax register. stop. In the present case, the petitioner has produced a copy of the no objection certificate. Has produced no objection certificate addressed to the respondent BBMP for in the present case the ಏನಾಗಿದೆ NSC ಇದು ಕೊಟ್ಟಿದಾರಲ್ಲ in the present case the Bangalore Development Authority, which has conveyed the subject property to the petitioner as by communication dated 27/8/2018 either 27/8 takes annexure F 2019 has by 2019 has stated issued to the respondent BBMP has stated that it has no objection for registering the Khata in favor of the petitioner in accordance with law. Therefore, it is expedient to dispose of the requisition, directing the respondent number to enter the name of the petitioner in the property tax register maintained by the respondent BBMP as specified under section 149(3) of the BBMP Act 2020 within a period of 4 weeks from the date of receipt of the certified copy of this order, subject to petitioner satisfying other requirements of law. You cannot harass the petitioner. Cost I'll impose cost 4 weeks. For 4 weeks. Yes. The petitioner was allotted with the site bearing number 1415 LIG2 situated at Suryanagara phase 1. The petitioner who was the subsequent purchaser of site bearing number 1415 LIG2 situated at Suryanagara phase 1, which was granted in favor of Srimati Suma M, submitted an application with the respondent number 2 for demarcation of the boundaries of this site. Petitioner's grievance is that the site application has not been considered. Learned Council appearing for respondent Karnataka Housing Board submits that the application submitted by the petitioner will be considered in accordance with law. Reasonable time is granted. Submission is placed on record. Therefore, it is expedient to dispose of the restriction, directing respondent number 2 and 3 to consider the 3 to consider the representation dated 6/4/2022 submitted by the petitioner at annexure A and pass appropriate order in accordance with law within a period of 8 weeks from the date of receipt of the subject, or 3 months from the date of receipt of the subject. Where is that notification? Annexure A. Yes, the reservation of wards is under section 8(3), 8(3) of the BBMP Act. One day in advance ಕೊಡ್ಬೇಕು.
Out of 145 constituents. So far as opposition party, 70 are reserved. Out of 145,
Yes.
So it is roughly for every two general wards, one is reserved for women, ruling party. So for an opposition,
Yes,
for every one general ward, 2.5 wards are reserved for women. When we go to the next, starting 145 constituencies, 50 are reserved. 98 constituencies, 70 are reserved. Now, this is Civic and Karnataka of Civic is of
Gandhinagar, all women. Civic all general. What reservation? SC, general, backward, general is it? No women.
Gandhinagar, general is 0, women is 7. Other wards, 7.
And what is the population?
Population is total population.
Male is 17,000. So the female population is less, but however it is reserved for women.
So far as Gandhinagar is concerned, population is more, 248. But still, all wards are reserved for. When we come to the next page, the knowledge of population is 243. Now, in Malaysia, out of 7 wards, 6 are general, 1 is no.
Sir? General andre other than women.
Other than, so 6 general and 1 is. Now, Jayanagar, the population is 229,000. One is general, 5 women. Now, Jayanagar is again opposition party.
Malleshwaram and Jainagar?
Malleshwaram is ruling party.
Ruling.
Jayanagar is opposition. Shivajinagar is opposition. Now, Shivajinagar again can we see the population, 211,000. And in that, 1 is general, 5. Next page. All these constituencies, PDM, Jayanagar, Shivajinagar, all are opposition party.
Law opposition.
Now see,
all women.
general 1, 8 women, general 1, 6 women, general 1, 5 women, and general 1, 5 women. And next page number 5. And just for all the constituencies, 5 and 6 are constituencies so far as ruling party are concerned. Now all we see.
So constituencies held by the opposition party.
MLS,
there it is reserved for women.
And wherever ruling party is there, more or less it is reserved for general. No woman is there. And even in the first chart, come back to the first page. The differentiation in number of wards. Number of wards, ruling is 145. In that, only 50 are reserved for women. And when it comes to opposition, it is not 145, 98. Only 98 wards are there in opposition party constituencies. Out of 98, 70 are reserved for women. This is what you want to demonstrate. This reflects Either if it is randomized or cannot be to an extent detrimental to the interest of other parties which are not in power. This max of power.
The last three elections, including 4 elections, the end to each company and the reservation I have mentioned very clearly. Third, authority war number 158 now. It was earlier of the duration of RPC level in the year 2001. The western part of Proceedings is called Vijayanagar ward. The eastern part of Proceedings is Amrinagar. There are page number 2 reservations of Vijayanagar ward. 2001, Vijayanagar ward number 23 general. Vijayanagar ward number 123 in 2010 general. 2015 backward class women. In 2022 is general. RPC level, my lord, it was called RPC level. Vijayanagar and Vasadi. Then was RPC level ward. RPC level to ward number 54 backward class A in 2001. Continuously thereafter, 2010 it was reserved for general, 2015 general, again Amrinagar, now it is reserved for general. Finally, the reservations for Vasadi ward, page number 3, 2001 backward classes A, 2010 Vasadi 124 backward classes A, 2015 Vasadi 124 general women was also reserved. Again 2022 158 backward classes. It's completely goes to show the rest it has complete the respondents have fully it is opposition party constituency. This Vijayanagar ward. This qualification is completely unacceptable. Why? Because ಯಾರು ಅಧಿಕಾರದಲ್ಲಿದ್ದಾರೆ ಅವರು ಮಾತ್ರ vested interest and political ventures has played role. What should happen to the common people aspirations? And if this is going to happen, and if it is allowed to happen as it is, the aspirations of the public people at large will be damaged, and aspirations of the constitutional institution itself is damaged. ಸಾಮಾನ್ಯ ವ್ಯಕ್ತಿಯ ಮತ್ತು ಸಂವಿಧಾನದ ಆಶೋತ್ತರಗಳಿಗೆ ಧಕ್ಕೆ ತರಂತ ಒಂದು ನೋಟಿಫಿಕೇಶನ್ it has to go. It's never too late to rectify. What should happen to those who are not approved with the Sangha report, hoping that they would get justice? The complete failure of justice now. What they have done is highly unacceptable. As we request this Sangha report is to stay this notification.
Having reservation since 2015, now my lord, BCA, the objection they have filed, they have said for backward classes, reservation even now is in the randomized cannot be random section 7, section 8 out of the scheduled caste, scheduled tribes, and also the OBC actually by rotation. When the act says you have to rotate, they can't say randomization is also a form of rotation. For example, the block is at 12. So from 1, 2, 3, and 4, so it is random, it will be at 12. When it is available, it will go to 11. It is not equal to 1. That can't be. The act says rotation in section 7 and 8, here it says for scheduled caste, scheduled tribe, and also for the OBC, has to be through rotation. They can't say So scheduled class and scheduled track will follow a particular pattern of reservation. And for OBCs, we do randomization.
Where you get the section?
7.
So they allotted the rotation into different Watsons. Yes, sir. Proviso to subsection 4.
These are in section 3 and 4 and allotted rotation. Randomization remains rotation. So there is no pattern of movement that go anywhere. In specified way saying there is no repetition. When they have rotation, the particular pattern of movement.
Two 43.
First, I will read the clause 1 by 1. Seats shall be reserved for SC and ST in every municipality, and number of seats so reserved shall bear as nearly as may be the same proportion to the total number of seats to be filled by direct election in that municipality as the population of the SC in the municipal area or of the SC in the municipal area bears the total population of the area. Such seats may be allotted by rotation to different constituencies in the municipality.
243. 243.
243, my lord.
ET.
Reservation of seats. That which speaks about municipality reservation of seats. There they have used for SC and ST municipal corporation, it should be on rotation basis. Where in our government has stated in the application to one of the scrutiny committee, they have followed the principle called randomization. Randomization never comes into play, my lord. It should be going should be taken by the determination of the population, even selection of PCA and PCB method, that is with respect to then census which is collected to empirical data. Second method, in the same clause, not less than 1/3 of total number of seats SC, the seats reserved under clause 1 shall be reserved for women belonging to SC or the case may be SC. But subclause B, not less than 1/3, including number of seats of reserved for women belonging to SC and SC of the total number of seats to be filled by direct election in every municipality shall be reserved for women and such may be allotted by rotation to different constituencies in the municipality. That's also for allotment of women in rotation principle. The subclass 4 and 5 that talks about the chairperson. So want to play. Subsequent to present case which is running with respect to Suresh Mahajan.
Yes, paragraph.
And this the OBC pattern one with respect to delegation committee method. In Rahul Ramesh work was the state of Maharashtra.
This matter is connected with Suresh Mahajan. In WP civil number 278 of 2022, say that matter 10-5, the judgment was passed by God. With respect to that, that matter still in the process. 29th, again, the matter is coming, my God, it's not disposed. In that, said, page number 5, my God, I want to direct the e-page. Page number 7, e-page. E-page number 7. In so far as
providing the final.
I don't want to someone said
randomization. Because the act and the article provides says that it is by rotation and not by randomization. Yes,
by
interim model stay other it will never come up again. Final dispose of. Anyway, the report does not contain any empirical data, how the data was collected, so what is that, on that ground only it has. And moreover, some of the constituencies, all the wards have been reserved for women. On the face of it, actuated by Malafites, because it should be done by rotation, not by randomization. Yes, yes. Even otherwise, it should have been distributed proportionately. Yes. It should be distributed proportionately. We cannot reserve post in a constituency held by the opposition party for women, and in respect of the constituency held by the ruling party, it is reserved for general category. Not general, but exclusively women. Then why reserve post for women? Remove, everybody can contest. Yes, women is. It can be provided in the constituency held by the ruling party also. Not separate. On the face of it, delimitation of what? Yes, there were some discrepancies, but still. But in this, yes, yes. No. Once if the report goes, the entire notification goes. 29th, we can postpone that. It has to be decided by 30th. It has to be decided.
what are your arguments? Because someone argued in the matter to write this.
Yes, yes. Mainly we'll go on the report, and secondly, reservation of posts for women in particular constituencies held by the opposition. On those 2 points.
Then we can one can do not consider the facts. These we can process that extent a lot of them need to stay and stay. And later on, you are really so we have that also in the
Yes.
Easier for everyone. All the reading will be completed. What will be better?
90.
What is
Arguing the matter now, somebody says there is shortage of time. Question is, what should say there is shortage of time? There is also say that shortage of scale never to this school everybody around. I have to go to because when it comes to conclusion, and surprise the other says yes, do not say that we do the matter within the time period. What is the mistake? So that no elections
Then on the face of it, it is prima facie, it is not in accordance with this one. Advise the government to redo the matter within a time frame. Because even going by the report, it is defective. Yes, sir. No, SC, I'm not going to. One is the question of reservation of post women and the backward classes. Other backward classes. So the report does not contain where the data was collected with regard to the population of the backward classes. There's a report, but where's the data which was collected? No, notification goes, report goes automatically. Yes. No, the notification is issued on the basis of the report. So once the notification goes, report goes automatically. Yes.
This is striking down back and what is the viability of the report or the government order checking the report. That has to be independently examined.
So once the report goes, the entire notification goes. Even the reservation of the wards to in favor of the women. Yes.
One, can't see. Suppose you want to see the categorization of women is wrong. It should not be done in this. But it shouldn't be because we have made every single category. That's why it's on. Across all the vertical division it does. So then everything has to be done. But then redoing will also require exam. The question is whether the report in any form can be used in some part of the world.
Once the report goes, it goes in its entirety, not in backward category.
Yes. People again everything. Then what should be done? It could be a question. For this, we have to make solutions. Because it is not simplicity as the reference see. Now we put everything in
Sorry, we'll direct the government to read the matter within a time frame and conduct election.
That is the next part.
Only on two limited points. So that is, one is the report, the reservation of post to the backward classes. Secondly, the reservation of post to women on this class. Only on those two. Not going to the other question.
.9, Lordship.
Yes, sir.
Similar case mine also.
Yes, yes, report. Which is the petition challenge to the report?
WP 18631.
Month reservation challenge. Yeah, which is the serial number? Madam, 94.8. ಇದ್ರೊಳಗಿಲ್ಲ ಮೇಡಮ್. 18631 ಇಲ್ಲ. It's only the notification which is challenged. No. Only challenge the notification. Sandeep Patil, which is that matter where the report is challenged?
1861.
Yes. Commission, not required. Depend on report. The notification. No. Report. Inquiry officer. Inquiry officer is not made. Inquiry officer is not made a party in commission. Yes. Yes. So you don't want disposal of the writ, but she wanted to keep it pending and
all points are there. Hurry. Election solution was prepared. All these points, what was you don't have an impression that we just want to say and the last is the rate of we'll finish it on that day. But for all these matters, casual matters, answers
commission report indicates that there is no data available. First, on the face of it goes, and reservation of post for women, it is not done malified because it's only to go.
They don't want to defend, they want to complete the Russian can build and walk. They want to argue.
Government doesn't want to hold election, but they will not concede. They want a court order.
There is one more option, my lord, in this. My lord, with respect to Suresh Mahajan incident, the case, Pakistan court was not able to finally complete with respect to triple test, non-laid out and Krishnamurthy judgment because of the Gawali. Pakistan court was submitted, the Supreme Court was not satisfied with the order. Later on, this order was modified by submitting the second report, which made the government to give empirical data, nearly 800 pages, my lord. Yesterday, which I spoke to the Learned Senior Council of Madhya Pradesh, my lord, wherein I came to know that they have made use of several methodology in arriving the OPC report, where they have gone to house to make a census on those things, and they have even engaged the institution of population department, my lord, in order to survey the backward classes. Simultaneously, Andhra Pradesh Municipal Corporation also visited the Bhopal Municipal Corporation and
now the commission has to be made a party. Yes.
Commission reads a report. Ultimately, it is for the government to accept the report or to reject the report. So, what voice can the commission have to say my report is right? Then, perhaps I would the alternate submission is the elections are now immediate. All these issues can be done later, but there should not be any. And what is the case minutes if the other side wants to have the commission has to be made up. Keep this aside minutes, ultimately Supreme Court minutes, set aside even the elections. This will be subject to the result of the writ petition. Ultimately, the Honorable Supreme Court will set aside the entire elections and ask us to keep it pending. First, but later on, now delivered. No, it is not. With great respect, as the the orders do not speak. Let's see the orders. Respect to Maharashtra, respect to Madhya Pradesh, since there was already one report which was not completely data was not available. Second report was summoned, and the government supported the second report, and that the court has said all of this now, not the first report. So they got fresh margin now says. Therefore, election commissions cannot say, but instead of this dispute arguments, they will complete their arguments. So the one line sentence, one sentence.
The commission is a necessary party. Commission is not a.
Commission need not.
It's only a report. Either it can be accepted or rejected by the government. It is not binding on the government. Not binding on the.
The terms of reference order will make it clear. The terms of reference order is only because the Honorable Supreme Court said this is the political backward class. That is what.
340.
Otherwise, in every case, the backward class commission will have to come and answer that what is the role of the government. Supreme Court says it in otherwise, the government does not accept the report or keeps it pending. Can the commission file a report?
I'll make on clarification.
What we are attacking on a constitution, what is saying they don't have data. Now either government has to say, commission had the data, or commission itself has to say that I had the data. The government has just accepted the report and gone ahead. Now, what forms that data or what? Who has to handle the report? Who has to define that report? Government will say whatever they have submitted, they are accepting. Now, those records, those data are not given to the government.
Perusal of that report itself indicates there was no data available.
Yes.
So no need of, yes, sir. So no need of making them a party to the proceeding. It is for the government to say that yes, data was available. What was the data? It forms part of the report. If the data was available, it will be part of the record. Whether the data was there or not, it's for the government to okay. Along with the report, data also will be furnished. Other data ne illa adike. Allah, there's no reference to any data there in the report. There's no reference to the data at all. What are the data? Quite good. Once this goes, the entire notification goes. And even the reservation of post women. The women also, because it is not done randomized only to suit the political ruling party. There is nothing on the record, unlike how we demonstrated in the case of delimitation of ward. There was no malafide. This it is very difficult. Padindra substantiate. The interest of the citizens of this city, read to the matter. within a time frame 8 weeks and finish it off. Conduct elections. Government cannot drag on. Yes, it's dragging on. Yes, it's permission. And what you would say about the reservation of posts, the reservation of wards in favor of women? In some constituencies, en masse it is reserved for women. So there will not be equal distribution of representation in various wards.
Is not there where it was the words. We indicate where the words are. But the act does not provide any you but you remove this consequence out of the picture. And only look at the words.
For example, the parliamentary election. Can you reserve posts, the seats for women in one state? En masse. No, that's what. Going by. You take it as one unit, and if you reserve seat of MPs for women in one particular state, and the state which is held by the ruling party, there if you reserve all the seats for the general category. No, that's what has happened here. You cannot take it as a single unit. You take it as each constituency should have sufficient representation by women. It is not that one particular constituency has to be represented fully by women. All the constituencies should have representation for women. No, you divide the wards on the basis of a constituency, on the basis of the population of a constituency, and then you divide the wards. No, it should be equally proportionally distributed among all the constituencies. Cannot be confined to one particular constituency to be represented by only women. There should be representation. Yes, one unit as a constituency, and each constituency should have representation for women.
All the words not form part of one unit. Now that one unit not is one unit the other. There will be more men or less. So one value is the whole difficulty is the other side's argument is various. The fact that you must look at the constituency and then see whether it is made by the opposition.
No, not that. Proportionately, all the constituencies should be represented by women.
May happen, may not happen.
No, it should happen. It should happen. No, it should happen. Not in the first election.
In the first election, there cannot be rotation. It is impossible to have rotation in the first. So the rotation requires something prior to that. The first starting point for this rotation.
No, randomization cannot be in such a manner that all the seats for women is reserved for women in a particular constituency. Should have been distributed among all the constituencies. Randomization under one day kade hogagalla. What he then can concede on that. Yes. You are assisting the court, not the government. You are assisting the court. Yes, you are not. Please.
What I believe is the law. No, really wrong. I'm saying
you're not wrong. You know you're wrong. Yes. Throughout we should go. It is never ending. It will continue for months together. And people of this, citizens of this, ultimately the people will suffer first.
94.9, Your Worship.
Plural, common people, they don't come to the court. People who suffer, they'll never come to the court. Again, triple test and then distribution of seats.
4.9, Your Worship.
Yes, sir.
Your Worship, may kindly come to page number 7. Now, I will not take more than 5 minutes.
Yes,
page,
sir.
Page number 7 is the petition.
Serial number, sir?
Page number 7. I have given an abstract. 94.9 it is.
94.9.
Petition page number 7. I have given what's the statistical figure.
94.90.
Page number 7. 94.9. This is what.
Yes, sir.
185 ward. Roshan, may kindly see the what's first I mean the table that I have given. Ward number is 185. Roshan, may kindly see how it is spread over. Ejipura, that is one is general woman, scheduled caste, general woman, then scheduled caste. Roshan, may kindly come to clause number, page number 2.
What is that this is done for the first time. So there's no question of rotation. The election is
no. So for the last what column is concerned, first in the list it was for general woman. Now Roshan may kindly come to annexure A. 2-3 cases are places they have just changed that. Can I just take Roshan to pay annexure A? Last paragraph. 6th line from the bottom. ಬೃಹತ್ ಬೆಂಗಳೂರು ಮಹಾನಗರ ಪಾಲಿಕೆ ಎಲ್ಲಾ 240 ವಾರ್ಡ್ಗಳನ್ನು ಅತಿ ಹೆಚ್ಚಿನ ಪರಿಶಿಷ್ಟ ಜಾತಿ ಜನಸಂಖ್ಯೆಯ ಮೊದಲು 28 ವಾರ್ಡ್ಗಳಿಗೆ ಇಳಿ ಕ್ರಮದಲ್ಲಿ ಪರಿಶಿಷ್ಟ ಜಾತಿಗೆ ಮೀಸಲಿಡಲು ತೀರ್ಮಾನಿಸಿದಂತೆ ವಾರ್ಡ್ ಸಂಖ್ಯೆ 88 ಬಸವನಪುರ ವಾರ್ಡ್ಗೆ ನೀಡಿರುವ ಪರಿಶಿಷ್ಟ ಜಾತಿ ಮೀಸಲಾತಿಯನ್ನು ಹಿಂಪಡೆದು ವಾರ್ಡ್ ಸಂಖ್ಯೆ 185 ಈಜಿಪುರ ವಾರ್ಡಿನ ಮೀಸಲಾತಿಯನ್ನು ಪರಿಶಿಷ್ಟ ಜಾತಿ women ತೆಗೆದುಬಿಟ್ಟು they have substituted what's called scheduled caste. And it not also even last election also it was for scheduled caste. And this year also it is what's called scheduled caste.
Which ward number?
185.
185. Yes.
Ejipura, page number 7.
Page number 7. It was for scheduled caste last election.
ಹೌದು ಲಾಸ್ಟ್ ಅಲ್ಲಿ 2022ರಲ್ಲಿ ಫೈನಲ್ ಲಿಸ್ಟ್ ಬಂದಾಗ ಅದರಲ್ಲಿ ಜನರಲ್ ವುಮೆನ್ ಅಂತ ಮಾಡಿದ್ರು. ಹೌದು ಅಮೆಂಡ್ಮೆಂಟ್ ಬಿಟ್ಟು ಅದನ್ನು
no rotation.
No rotation, and they have removed that deliberately and put what's called ST in place of that.
Yes, what you said. Srinath Gaudre, WP number 18632 of 2022. Ward number 185. 2015 election, it was reserved for SC.
Now you can look at what has happened. And then there was that time it is the corruption huge body. Continuing back to the previous argument. Earlier, the hormone, then after immunization, avoid that not present guideline. Present guidelines is the list of reducing. That's not because all the
How is this perfect?
WP number? 94.7. That's a 18? 18609. ಅದೇ 18609. ಅದೇ ಅದ. Yes, then. You admit there's no data available. What is there? Okay, fair enough to admit the government, you are admitting on behalf of the government. No, most of the, among the staff, many youngsters are there were keen to argue. Political.
Understandings. Your options are setting aside the reservation. To read OBC. That's a second part. First part is the options, reading it. Suppose on the horizontal reservation, accepting for the CSP. Then the next, it's a question of redoing it, not more than 2 weeks after maximum. I would say they have to do it within 1 week. That was in this case, that is one. There is no need for it. Coming back to OBC words, the proposed condition report is set aside and they have to redo it. Question of redoing it or it's being set aside only because of lack of empirical data. That has to undergo members as census. Nothing can be expected in 8 weeks. 8 weeks is an impossible task. Number two, the victim of the court is if the triple test is completed, I do not need to wait. I have to go ahead. Once that
It is a judgment.
This I need the compilation. This takes this compilation. I complete then my learning.
Yes, sir.
That is how we stand.
Which is the judgment? Which is the judgment?
Start at 22. Just read from paragraph 12 so that we understand the concept.
On the notional bill, the state election ought to proceed without any exception, without even waiting for the compliance of triple test.
That notional basis, see, without any exception, the president of concerned local bodies where elections are due are likely to do without waiting even for the compliance of triple test to other backward classes. We have no manner of doubt that only such direction will give the end of justice and rapid that the local government must be governed by the elected representative uninterrupted except in cases of until the triple test formality is completed in all respects by the state government, no reservation for other backward classes can be governed. And if that exercise cannot be completed before the issue of the program by the state election commission, the states except reserve for scheduled castes and scheduled tribes which is impossible. The rest of the states must be notified as per the general category because that is in paragraph 14. Because that's the population of OBC in some of the local bodies is more than 3%. For that reason, percentage indicated in the report submitted by the commission It is completely approved and taken forward. That cannot be the basis to be physical the constitutional mandate and the need to observe different procedure indicated in this. The political parties who claim to be the protagonists of participation in OBC governance of local bodies are free to nominate candidates belonging to OBC category. The concerned constituencies given against all the general seats after reserving for scheduled caste and scheduled grades. We once again reiterate that the process of delimitation and the deputy compliance and continuous complex time consuming process without any timeline directly linked to the expiry of the term of the outgoing elected body. As the conduct of elections is duly elected to take over the rates outgoing elected representative who serves as a provided by the constitution and the relevant electments. Then para 16 again to say that this is what in para 15 16 that's what they say. And para 18 again they reiterate para 18 to put it differently, population of delimitation express or be it a triple test formality as the to be their date is not completed well before the expiry of earlier including giving enough time to election. So please see the last two sentences highlighted. Now, it is not only a constitutional obligation of the state agency, but also the state government, including of the constitutional court. That's the observation. That words, para 22, the lordships observed that the first report was not proper. Then words, how it has to be done is at para 24. In other words, the exercise of collation of empirical data and after analysis, the commission is expected to make recommendation regarding number of seats to be reserved or other target classes. Local body wise, apparently that experience has not been undertaken by the commission. Then only they can do it. Para 31, they said all these directions are applicable not only to Madhya Pradesh but to all the states. Para 31, running page 26. But to all states, union territories, and the respective election commission provide by the same law. This order was modified by an order dated 18th of May 2022, which your lordship will get at page 27, running page 27. What was done was, please come to page 28. Bottom panel reads started. Further, the report of the dedicated commission and been revised in the light of the observations made in the court. The second revised report came to be submitted to the commission, incorporating all the requisite issues, also giving the breakup of observations of other backward activities to be provided local body wise. This report has been submitted to the state government as well by the So please give the next panel, then the other panel, right panel in page 59. To reassure ourselves, we have gone through the report submitted to the dedicated commission. Proportion of reservation to be provided for other backward classes, local body wise across the state of Madhya Pradesh. The second report has focused on the proportion of local body reservation to be commissioned for other backward classes by keeping in mind the maximum reservation index. That words, they do not express any opinion of correctness. The only thing what they did was, please see at page 32nd panel. For the time being, we permit page 30. For the time being, we submit Madhya Pradesh State Election Commission to notify the elections of the respective local bodies, keeping in mind delimitation notifications already issued to the state government as of this date. And also the report submitted to the dedicated commission referred to whom. Then what is modified is they categorically say only to this extent. The earlier order, we see at page 31, the last 4 sentences. Third line from top. The directions given in an order, page 31. Running page 31, sir. The third line from top.
Yes.
Directions given in order dated 10/5/2022 and modified to the above extent That's the only thing which was modified. Thereafter, in Maharashtra also, that is because the Honorable Supreme Court, after having reached the report of the dedicated commission, accepted that the state government had accepted. So, earlier order below the commission report, they modified only the fact explained because they felt that the report was in line with the. Then the words Maharashtra also, the Rajut sees the case, how the Rajut comes to the first of the judgment because it is wrong. At page 1 it starts. That's when the whole thing started. This was a case where the elections were conducted without the triple test methods, but it was made subject to results of the writ petition. Where the lordships finally found that triple test is a mandatory exercise. And if the lordship says, please come to the para. Verse 26. Or you want to come and learn the running page 21. Para 28 verse. 28 para and running page 21 verse. As a consequence of this direction, declaration and direction, all acts done and decisions taken by the local body due to participation of members OBC candidates who are vacated seats. Terms of this decision shall not be affected in any manner, or they will be deemed to have vacated the seat upon pronouncement of this judgment prospectively. Under 142, wherever elections are held, the lordship said vacate, they are deemed to have vacated, conduct a fresh election for those seats. Now, to say I will have to avail for the triple test to actually defeat the constitutional mandate, more so than the case that the Honorable Supreme Court has said, do it fast. Please see because the Honorable Supreme Court's orders in Shivra's case, which the Lordship Supreme first of the case, and towards the page 45 minutes, page 45, that's the order dated 20th of May, 2022. Of May, the lot of categorically said PCN 48 and 49. 48 words. The assurance of the state of claims on record and the why I am trying to point out this order is the common thread is the Honorable Supreme Court also tried that there should be no further delay in conduct of elections. 48 they said they gave the state time to complete delimitation, dedicated commission work and reservation. Then at 49 their lordships observed that I should commence the exercise of the election within 1 week. Then the Lord's subsequent order came to be passed on 28/7/2022, which your lordships provided. Running page 51. The concerned order, my lords, please come to running page 53. The second paragraph of in that view of the matter. In that view of the matter, we direct the state government to notify ward-wise reservation card, local body-wise, within 1 week from today to facilitate the state election committee to appropriate steps for improving constitution of concerned local bodies within a reasonable time frame and other constitutional parameters. In case there is a grievance regarding undue delay in initiation of process by the state election commission in any local body across the state, it will be open to the appellate process to approve this course of appropriate directions. The idea of the board was granted and will compete with the reservation. That's why what I am saying. If you are not to the only reservation has to be made up. That's the woman. Otherwise, 1 week is enough. So granted the 1 week or 2 weeks. It is not an exercise which requires 8 weeks. The idea is if it goes to 8 weeks, it will go beyond January. If it is beyond January, the entire time schedule is violated. Here, we are in a position where we have taken on low medians from the Election Commission of India In the letters, we cover the election. Asking us to return the EVA. I have to balance all these things. Because it can't be that 8 weeks and repeat this. I don't need to wait. Because the court also towards the Supreme Court's direction is not only state election commission but even the constitutional court. Because repeat test has to be done in accordance with the census. It has to be a door-to-door census. But it cannot be done within 8 weeks. Now, if somebody says in 8 weeks I do a door-to-door census across the state, because it has to be across the state, not only one local body. And thereafter fix backward class reservation local body wise. Get the promotion. Afterwards, in 8 weeks, that is not an exercise. That can go on. We are not saying go do it. But that goes on more. I am into it. But the election commission will have to now convert all those OBCCs. But that cannot prevent you from declaring the election. To await triple test report. That's my compensation.
Yes. Yes. The first judgment. First judgment.
Paragraph 13. Paragraph 13. Text says, with no triple test, applicated from or said paragraph 13. Of the consequences thereof, stated paragraph 20. We go ahead with the election. Without OBC reservation. The elections itself would be set aside at a later point of time. That is what paragraph 20 says. But we are in a situation where there is time. This first time election happened for a new body under a new act. What for the election commission doing? Which they say OBCs are not there. I'll convert everything into general category and will conduct the elections.
The dictum of the Supreme Court in the case of because of
that general election was not set aside.
Suresh Mahajan case. Suresh Mahajan.
State that conduct the election with members. If OBCs are not available. Then the very same judgment, the second one says, now that there is a dedicated commission which has come out with a report. Now kindly follow that. And
So that report was accepted by the Supreme Court and there was a direction issued to go ahead with the election by.
Sorry, the first direction was have to be over. There was no question of OBC at all.
Because there was no report. There was no report.
There was no
Report. Now there is a report.
So thereafter, there was a report. After the Supreme Court judgment, there was a report. Actually, there was a report initially also. That was the first report. Then the second report came out. Now the second direction, second time when the issue comes up, US market, Supreme Court says, now that you have this in your hand, kindly notify the electorate. Follow this report. So far as OBCs are concerned. Now kindly compare to the first direction. The first direction only said no OBCs, go in general. But with respect to the same local body, same state, that direction was changed. Because now they have a report. Now what we are now saying is, there is a report here. We confidently, it's
a report. So we can direct the government to proceed with the election in view of the report.
Either in view of the report. Our report is all to be multi.
Then treat all the seats as general category seats and proceed with the election as per the first judgment of the.
Then we will vote against the constitutional system. This judgment is not a constitutional requirement. But this judgment of fresh market as well as because of the judgment of three judges. But whereas the triple test one which covers the judgment of constitutional. But now we are in a situation where there is a report which we have assigned to the and the court is of prima facie that the report doesn't have the requisite additions or parameters to hold it. and the elections would be conducted on that basis. Now, if the government were to be directed at this stage, the report can be redone. 8 weeks time.
Shabakala, collection of data all over the state. It is not possible within 1 year.
That can only be said not by the election commission. It can only be said by the delegated commission only. That statement cannot be made by anyone else for the world.
How do you overcome the first judgment of Suresh Mahajan?
Judgment was delivered on 10th of May 2022. The second order, however, that's not a judgment. Came on 18th of May, within 8 weeks. That's the only thing. It's not months together. Within 8 days, the second order came in Suresh Mahajan.
How do you overcome the first judgment? There was no report. Yes.
Write down the report and what is the consequence for answering. Either the case was there is no report, therefore this is the consequence. In the other case, we are when the report was there, this is the consequence. This much is the problem, not the final case. Therefore, this is the consequence. In the case in Maharashtra's case, there was no report at all, no commission, nothing. Therefore, the audience can't simply apply those two principles to see that what is the court says to model.
Once the report is called, there's no report. Yes. Yes. One consequence, once the report goes, there's no report. So you are bound by the decision of the appellate court in the case of Suresh Mahajan.
Almost like that because you did not do all that is required to be done. Therefore, I am passing this order directing the general category to the OBCs. We have not done all what was required to be done. Now, in case we went to the Supreme Court, what time established the commission came to be, commission gave a report. Now, you strike it down, what should the consequence not answer by this? Therefore, you are with all logics of not like very much say that the report must complete company's work. It is really only that.
To collect the data all over the state is not possible within 8 weeks.
It was not possible. 8 weeks, time granted was this delimitation. The report itself could never have been published. It was done. Now, there are some flaws in the report which some point out. Then the logic will have to analyze the report fully and make a determination. That is something what they also going to do. We have to examine it and now,
only on the basis of empirical data was not available.
the commission has given in one paragraph.
What is the difference that along? What is that? What is the data which was available? What is available?
The argument is the same. The argument is not vested rights. The law and say, do it this way. And therefore, dissenting them would be entitled to participate in the reservation. But if they still want to participate in general activity, they always can. But in this, everyone's including work, to get dissenting of participating in the reservation in that category. That also they get dissented. So it is a very serious consequence because taking the report speaking now. And the other thing must do complete relation. Even if ultimately you don't say that, but say that the commission must take these parameters as well and submit a report. Because logics are going to put in a completely different scenario. It's not covered in this judgment. It's why I went to the beginning of the situation of there not being a report. What the constitution court says this report is not in accordance with what we want to be. It is a completely different scenario. Which way the commission should be asked to do it in that way. The commission comes back and I can't do it. It's not possible for us to do it in the right way or otherwise. Then what should be then done is another system that or as it was done, it takes the report as it is put out. Direct elections to be held. Analyze it as well can be done properly because we are now directly to the election. This case.
ಹೇಳ್ತಿರೋ ಬಸ್ಸಸ್ ಇಲ್ಲ ಅಲ್ಲ
At this point in time, ultimately not whatever material is there in place, so you have to sustain the report.
Whether it is in the particular, quite honestly, the seventh year. R plus leads to non-monomer. Leaching places non-monomer. Doesn't the report? We accepted obviously we have no issues. But to say the government, then if the report was time to complete the enumeration of the test, thereafter the elections will do. That is not what. But we will also just read page 5 of the report. Population statistics are given. That is what is the answer. That's not the issue here.
Any page?
But in the repetition, 18609.
Yes.
Not page 65. Running page 65. There is a table. That is where minorities population is mentioned, other backward classes population, others population is mentioned. Total population is mentioned as 61 lakhs. That's total population. I have to say more because census population of 2011 was about 84 lakhs. That is the only issue here. The others are going to do that issue. How this population figures came over. SC, ST, I can understand somebody gets it from census. But apart from SC and ST, no other population figures will follow. Minorities is another backward classes. Population across the state is. Now that words can be enabled. That can be only by a door-to-door survey. That is probably not for me. That's what I'm saying here. Somebody has to understand.
Yes. Yes.
OBC.
The OBC and the minorities is not available. So far, yes.
Backward classes are no political background. And political background is not the unit has to be the local body. There could be not a place, local body where, for example, I'm saying, that the unions are a political background. But in a place like Bidar, for the local body, but politically they are followed. You don't have to give them a. That is the whole idea of find out political background. That is the yeah,
Political backwardness in the local bodies.
The local body.
In the, all over the state.
That's not required. So how they must data they must gather. And there was this must be a permanent commission. It's not same way as how many years who are the class who represented. They take a determination.
Door-to-door census is not required. It's only the representation. If there's no representation of a particular backward class, then treat them as politically backward class. Backward. And if there's representation by the backward class or a minority in a particular local body, they cannot be treated as politically backward.
That is the case. 33% what is given here, based on population. If what it comes to the report, then now things outside the report are not using the report. But if you not come to the report, it is please see 163 notes. Running page 163, internal page 103.
163?
But the
internal page?
Internal page 103 of the report.
103.
The last taking into consideration 44.40% of total population belong to OBC, including minorities. So the population has played a role here. The population based on population. that's why I'm saying, either you allow us to go ahead with this, consider this report later. If this report has to be redone, then the elections go on, because waiting for the repeaters. Or it can go on, it can be used for the next election. It can never go on. Next election does not arise. I'm saying I'm giving up. I'm not challenging this report. Not against this issue. This 44%, they're not at home. But the lordship saw that 44% is 5 page 103.
Yes.
Return on page 103. The lordship compares that with return on page 5.
Yes.
15.73% is minorities. OBC is 28.67%. So that comes to over 40. That's the other problem.
So the first case. But how do you overcome this decision of the Supreme Court in the case of Suresh Mahajan? No, it was accepted. Here, there's no report. In the event the report is quashed by this court, there's no report. Then the first direction issued in the case of Suresh Mahajan, we are bound by that. There's no report. Yes, court election. No, how do you overcome the first direction in the first time frame? The first case, that's in the case of Suresh Mahajan, where there was no report, the Supreme Court said that go ahead with the election without reservation, providing reservation to the backward classes. So according to the second judgment, in view of the second order, the first direction stands diluted. That's your submission.
Now the state government is very badly coming for.
Yes, sir. What do you say, sir?
Matching that report. If your lordships find that it is not satisfying the triple test, or that it does not contain a particular ingredient which is necessary, that is enough to say that is not a report meeting the triple test.
No need of
Not
question.
that your lordships are watching the report or doing anything. Your lordship may kindly see the report in all, let us give the highest possible margin. There is not even a word pointing out which are the community in the OBC, which is OBC that they refer, in the OBC which is the identified for the purpose of admission and reservation in education and for appointment. 15, 16 ಏನು ಐಡೆಂಟಿಫೈ ಆಗಿದ್ದಾರೆ ಅದನ್ನೇ OBC ಲಿಸ್ಟ್ ಅಂತ ಇಟ್ಕೊಂಡು ಅದನ್ನೇ ಪಾಪ್ಯುಲೇಷನ್ ಅಂತ ಒಟ್ಟು ಹೇಳಿದ್ದಾರೆ. Supreme Court has said that reservation is altogether different. Political reservation is different. It should be a different inquiry, empirical test. I just, as a matter of example, your lordship may kindly see, certain community, for the purpose of reservation under 15 and 16, comes under chapter 2, category 2A. But that cannot be a community among the backwards which can be categorized as politically backward. On the other hand, that particular community which has reservation for article 15 and 16 in chapter in category 2A, which may have to be, some of them may have to be excluded because there are more politically backward communities which require the reservation. Even Procedural Committee report itself says this list which has been made should be subdivided into another two, but it can wait till 2027. That is on the premise. Now we don't have time. Therefore, before for conducting the election, you do this. We will do it all later. Empirical data with regard to political backwardness of classes which they take as politically backward. ಅದರೊಳಗೆ ಆ ರೀತಿಯ ಎಫರ್ಟ್ ಇಲ್ಲ, ಆ ಪ್ರಶ್ನೆಯನ್ನು ಮಾಡಿಲ್ಲ. ಅದು ಒಂದೇ ಏನ್ ಹೇಳಿದ್ದಾರೆ ಅಂದ್ರೆ ಇದು ಸಬ್ಡಿವೈಡ್ ಮಾಡ್ಬೇಕಾಗ್ತದೆ ಈ ಲಿಸ್ಟ್ ನ, ಬಟ್ ಇಟ್ ಕ್ಯಾನ್ ವೇಟ್.
So no need of quashing the report, only the notification can.
Notification saying this report does not satisfy the minimum requirement of minimum triple test. Not that your lordships are finding fault with this thing, quashing a report. On the other hand, it should satisfy these criteria which has not been satisfied. Therefore, that cannot be the basis. That would be the.
Then what about the direction issued in the case of Suresh Mahajan?
The consequence is, if they have time, if they are willing to do it, they should take it up on war footing and do it immediately, and allow the election to be held within a time frame. If they don't have that political will to do it, there is nothing else except following Mahajan case, that elections will go on without that reservation. That is with regard to OBC.
Make submission tomorrow, the second instructions, and make submissions tomorrow.
That is with regard to OBC. With regard to one of the matters that we pointed out, with regard to the constituency in WP 18592. Of course, my reference appearing for the election commission, that data is available, but if you have to come to the government. Kindly see page 93 and check that.
590. Yes, sir.
Page 93 what is it? That is 590.
Yes, sir. Page 90.
Page 93. Initially, entire was one constituency. Now, there are 3 divisions in that.
The Gormau.
Usually, according to our allegation, the yellow portion is there. Earlier, Gormau to ST population was 3/4 of that ST population would be in this division, which is shown as yellow portion, which is now made a separate wall.
The yellow portion.
Distribution, what we are asking, what we are finding out, our allegation is how they found the SC population available in this.
ರವಿ ಕರೀತಾವನೆ.
I don't put it in this way. In the sense that maybe a round figure with regard to what might have been given. If that word itself is bifurcated, unless the instances because they have definite figures data available with regard to, let us say, in a one current survey, until the head might have a construct for what in that another block. For those blocks might be they have a census figures available, but that should be made shown that these figures are available in the census. Otherwise, they will have to say, after this division for this, for the purpose of ascertaining, we have undertaken an exercise. It's not something that can be in a theoretical manner.
Population, your lordship sees this chart. They are all produced. Oh, the ward-wise population is given, SC, ST, the ward-wise population, that's extracted from the census. Now, let more than this may not know, your lordship says, for each ward, general population, SC population, male, female, is extracted from general census population.
General census ಈ ಏರಿಯಾಕ್ಕೆ ಜನರಲ್ ಸೆನ್ಸಸ್ ನಲ್ಲಿ ಫಿಗರ್ ಅವೈಲೇಬಲ್ ಇದೆ ಅಂತ ತೋರಿಸಿದ್ರೆ ಅದಕ್ಕೆ ತೆರಿಗೆ ಬೇಕಾಗಿಲ್ಲ. ಎನ್ಯುಮರೇಷನ್ ಬ್ಲಾಕ್ಸ್ ಗೆ ಫಿಗರ್ ಇದೆ ಅಂತ ನಾವು ತೋರಿಸಿದ್ರೆ ಸೆನ್ಸಸ್ ನಲ್ಲಿ ಇದೆ ಅಂತ ತೋರಿಸಿದ್ರೆ that there is no question of I saying number is they are saying number is this number as in 2011 is available in the census.
Tomorrow, 2:30. After vacation.
I may make a mention.
No, not possible. Or after vacation.
Around 63, it may be had tomorrow, my lord.
Madam, not possible, madam, tomorrow.
My lordship, in the morning I had moved a matter, my lordship. That
Yes,
may
sir,
be
2:30 matter. No, not the.
it has to be connected with 94, my lords. It is also on the similar.
No, it is not possible because of this reservation matter.
My lords, my matter is also similar, my
Come on,
lords.
10th or 11th. No, one day, let it come, sir. I was not inclined to grant the relief.
My lordship, for 2:30 I had moved a matter,
Yes,
my
yes,
lords.
yes. Wait. It's called out. Srinivas, yes.
Please, my lordship.
Yes. It is a BBMP.
My lords, it may be connected with 94, please.
Reservation, huh?
Yes, my lords. 94 itself.
That's
Connected
94.
with the, please, my lords, please, my lords.
My lord, serial number 90, my lord. With regard to, I am not challenging the elections of the BBMP, my lord. With respect to name, my lord. Instead of
Name will take it
Konehalli,
up. ಆಯ್ತು ನೋಡೋಣ ಆಮೇಲೆ ತಗೊಳ್ಳೋಣ.
ಇಲ್ಲ ಅದನ್ನು ಸ್ವಾಮಿ ಇದ್ರಿಂದ ಅದು ನೇಮ್ ಹೆಸರು ಮಾತ್ರ ಕೇಳ್ತಾ ಇದ್ದೀನಿ ಸ್ವಾಮಿ ನಾನು.
ಆಯ್ತು,
ಇನ್ಸ್ಟೆಡ್ ಆಫ್ ಗೌದೇನಹಳ್ಳಿ
serial number 90.
ರಾಮಮೂರ್ತಿ ನಗರ್.
ಒಂದು ನಿಮಿಷ, serial number 90 Friday.
Much obliged.
Page 34. PC director took the report and the next immediate action. HSG and page 34. This is dated 18/7/2022. Then town panchayat also directed the PDO so that on the spotting section and take action. I don't know. Then Ashindra issues a notice and HSG page 36. This is what it says. From 36. Satri. ಮುಂದುವರೆದು ಸತ್ರಿ ಬಂಧನಕ್ಕೆ ಹೋಯಿತು. ಈ ಬಗ್ಗೆ ಯಥಾಸ್ಥಿತಿ ಕಾಪಾಡಲು ನ್ಯಾಯಾಧೀಶರಿಂದ ಆದೇಶ ಹೊರಡಿಸಿರುತ್ತಾರೆ. ಆದ್ದರಿಂದ ಸತ್ರಿ ಬಂಧನದ ಬಗ್ಗೆ ಈಗಾಗಲೇ ಹಲವು ಮಾಹಿತಿಗಳಿಗೆ ನಿಗ್ರಹ ವಹಿಸುವಂತೆ ತಿಳಿಸಲಾಗಿದ್ದರೂ ಸಹ ಕಟ್ಟಡ ಕಾಮಗಾರಿಯ ರಚನೆಯನ್ನು ಸ್ಥಗಿತಗೊಳಿಸುವಲ್ಲಿ ಹಾಗೂ ಪಂಚಾಯತ್ ಅಭಿವೃದ್ಧಿ ಸರ್ಕಾರಗಳೊಂದಿಗೆ ಸಮಾಲೋಚನೆ ನಡೆಸದೆ ಯಾವುದೇ ಬಂದಿರುತ್ತದೆ. ಈ ಬಗ್ಗೆ ಇನ್ನು ಮುಂದೆ ಸತ್ರಿ ಪ್ರಕರಣದಲ್ಲಿ ಕಟ್ಟಡ ಕಾಮಗಾರಿಯ ರಚನೆ ಮಾಡಲು ಕ್ರಮ ವಹಿಸುವುದು ಅವಶ್ಯಕತೆ. ಆರಕ್ಷಣೆ ಇಲಾಖೆಯ ರಚನೆಯೊಂದಿಗೆ ಹಾಗೂ ಪಂಚಾಯತ್ ಅಭಿವೃದ್ಧಿ ಸರ್ಕಾರಗಳೊಂದಿಗೆ ಸಮನ್ವಯ ಸಾಧಿಸಿ ಪ್ರಕರಣದಲ್ಲಿ ತುರ್ತಾಗಿ ಕಟ್ಟಡ ಕಾಮಗಾರಿಯನ್ನು ಸ್ಥಗಿತಗೊಳಿಸುವುದು.
Learned AGF for respond number 1. Issue 1 and 3. Issue emergency notice respond to 4 to 9. ಏನ್ ಮಾಡ್ಬೇಕು ಇವಾಗ? ಯಾರಿಗೆ who is the complaint of? No, who is the complaint of the fifth respondent? Respondent number 5 to forthwith take course steps. Respondent number 5 to forthwith take steps to stop the construction, illegal construction, to stop the construction, to stop the construction of the building, the construction of the building. Then temporary.
That is why DC
To stop the learned counsel for the petitioner submits that though the Tahsildar has passed an order for removal of for stopping the construction put up by stop the construction put up by response 6 to 9 without obtaining building license. The respondent number 5 have not taken any action. Other issue notices. Respondent number 5 is hereby directed to take action for stopping the construction. To stop the construction put up to stop the construction put up by respondent 6 to 9. Respondent number 5 is hereby directed to take appropriate steps to stop the construction of the subject property by the respondent 6 to 9 if the construction put up is without obtaining building license. Yes. Come on. Jaipur. Hello, you have to go for Kalburgi bench. Kalburgi bench. No, I'll not entertain. Kalburgi bench. Sir, filing a fresh bill in the work on that this subject. ಇಲ್ಲ ಇಲ್ಲ ಅವ್ರು ಇರ್ಬೋದು ಬಟ್ ಕಾಸ್ ಆಫ್ ಆಕ್ಷನ್ ಅಲ್ಲಿ ಯು ಕೆನಾಟ್ ಕಮ್ ಅಂಡ್ ಫೈಲ್ ರಿಟ್ ಪಿಟಿಷನ್ ಬಿಫೋರ್ ದಿಸ್ ಕೋರ್ಟ್. ಕಲಬುರ್ಗಿ ವಿಜಯಪುರ ಎಲೆಕ್ಷನ್ ದೆನ್ jurisdiction is the council of fraud in the matter for some time. 6 of this court to withdraw the petition, reserving liberty to file a petition afresh before the Kalburgi bench. Submission is placed on record. Petition is accordingly dismissed as withdrawn, reserving liberty as sought for. This is the government advocate. Yes. B group. Thursday what is Mugibakal reservation Friday. Friday will put it up. Friday. Yar Harish Bandari. Synopsis ಮಾಡ್ಕೊಂಡು ಬನ್ನಿ ಅವರು. Number 5 minutes. Covered ಅಲ್ಲ ಇದು? Other than compensation. 14B. When was the formation of the utilization of the road? Utilization line?
The others are in the 2019 and 20.
Friday month. You have 4, madam? Yes. Thursday not possible, right? Right? Yes. 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 October. Next week is vacation. After vacation. No, not madam. Interim order is operating, madam. Why you want to? Then after vacation.
Court officer, madam. Court officer, madam. Court officer. Court officer.